Well, we're on YouTube. Now all I need to do is get my Acrobat to work. All right. I'm able to make it work now. Right, I'm going to call the dockets. As for announcements from the attorneys, anyone who is present who does not have an attorney or whose attorney does not answer, please make sure I know that you're there. Otherwise, please make sure your microphone is muted. Begin with Karnes County in the matter of the marriage of Joseph Garza and Karen Martinez.
I'm present, Your Honor. It's a motion to modify. I'm ready, and I would anticipate that I will have no trouble getting my side done in less than an hour.
All right, is Karen Martinez present?
I talked to her last night and sent her the logon information. I talked to her again this morning. She called and asked me if I could delay the login. I told her no, and she told me that she was going to go home and log in.
All right, there is a telephone with an 832 area code that ends in 317. I'm asking them to unmute. What is your name?
Yes, Your Honor. My name is Claire Portis. I'm here on a different matter. I'm here for Troy Capital this morning.
Okay, and I'm sorry, your name is?
Claire Portis. I'm an attorney for Troy Capital.
Okay, thank you.
Your Honor, I don't mind waiting till the end of the docket. Let's see if she logs on.
Okay, we'll give her a few minutes. Okay, LaSalle County, Maltzberger Story versus FEV Record et al.
Yes, Your Honor. This is Austin Brister. I'm also here with Michael Szymanski and Carlos Soltero. Your Honor, we actually have 9 default judgments in that case. We have 2 default judgments in another that you haven't named yet, 1 in a third. So I think that's a total of, I guess, 12 default judgments and 1 suggestion of death. I would think 10 minutes between all of them. If Your Honor wants to review all the orders and sign them at the same time, which would be fine. I mean, it might take a little bit longer, but they're all the same on the same types of issues, same types of cases.
Let me ask Mrs. Scaler, where do we stand on getting me access to your records?
I talked to LGS and they were supposed to contact you, Judge, at the beginning of this week.
All right. All right,
I can call them again this morning.
do you have copies, Mr. Brister, of all of your returns of service? Courts file?
You know, I do, Your Honor. I was prepared to upload my proposed orders. In about 10 minutes, I could get all the returns of service prepared in a folder to upload all at once as well. Okay,
if you would do that, I would appreciate it. And okay. Let me just ask, I only have 1 case down. What are the other cause numbers?
Your Honor, there were 4 cause numbers. One of them we're passing on, and so I would like to note that. I can do that later. The 3 that are going to be in front of you today are the one you named, which I believe was 20-06-00106 in the 218th. Right. And the named defendant is FE record. The next is 20-07-00134, also in the 218th. First name defendant is Sally Hentz. The third matter is 20-07-00135. That's in the 81st. First name defendant is John McLean, Jr.
Okay, all right, if you would upload all of that, and like I said, Ms. Esqueda, I'll just ask you to look on those 3 cases and tell me if there have been any answers filed.
Yes, sir.
And Your Honor, would you like me to upload the returns of service and the proposed orders now, or just start with the returns of service?
Both.
Okay, will do. Thanks.
Okay, Atascosa, no, let's do Wilson County. Wagner versus Mendiola.
Eloita present for plaintiffs.
Travis Mendiola present, Your Honor.
This is, we were conferring, ultimately we weren't able to reach an agreement. However, I think Mr. Mendiola currently has a pending motion to continue to reopen discovery. And so we can move forward on that. I imagine that's probably 5 minutes.
Okay, what motions do we have to hear this morning?
It's a Mr.
I mean, for Mr.
Mendiola.
Mr. Mendiola, do we have motions of yours?
No, I just was entering in some, well, the discoveries, because I had sent them some previously, but a lot of the pictures were, they were all blurry, so I sent some better pictures with better clarity to them. And basically, I've been able to get a hold of Mr. Hitta through email, phone number, his phone number.
All right, so let me ask, do you have any motions that need to be heard this morning, Mr. Mendiola?
Well, I would like to make a motion for a jury trial.
All right,
Because
sir, I've got to tell you that I can't be your attorney, but I can tell you that that has to be done in writing. Okay, and it's not just something you do in court.
I've already submitted, I'm sorry.
Are there any written motions that you have filed that we need to have a hearing on today?
Yes, Your Honor. He has on file a motion to continue to reopen the discovery period, and then a motion without leave of court to request a jury trial. Mr. Mendiola has those pending right now.
Okay, and they've already been filed in their opinion. So how long to hear all of that you expect?
5 minutes.
Okay, I'll mark you conferring for right now, and I'll mark you
Yes, sir.
10 minutes.
Okay.
Matter of the marriage of Beatrice and Benito Marroquin.
Judge, that was disposed on January 8th.
All right. Okay, and back on Karns, in the interest of SIM, a child, that's 19-5-126.
Yes, Your Honor, I am present on that. This is opposing counsel Anna Laura Hesbrook's motion to enter.
All right. Anyone from Ms. Hesbrook's office? Okay, I'll ask you to give her a call. I don't want to just end this and then she shows up 5 minutes later and says she was presiding or something.
Okay, I will give her a call right now.
Thank you. In the matter of the marriage of Gianna Morales and David Cantu.
Present.
Okay, and is your husband present also?
No, he is currently locked up and he is not wanting to participate.
Are you ready to proceed?
Yes.
All right, ma'am, I will mark you A. You'll be the first pro se call up.
Okay, thank you.
That is the first self-represented. I take the cases where people uncontested with attorneys first. All right, in the matter of the marriage of Dominic and Willie Campbell.
Present.
All right. And are you ready to proceed, ma'am?
Yes.
And is Mr. Campbell online?
No.
Okay. All right, I will mark you B. It'll be the second self-represented case I call up. All right, San Miguel versus Peeler in Atascosa County.
Louis Sutherland for San Miguel, present, Your Honor.
Mark Guthrie for Kiewit Mining Group, Your Honor.
Mary Whittle for the Peelers, Your Honor.
Okay, I don't know if the client's going to show up or the other side on Mr. Vestal's case. What I would ask right now is, why don't y'all come back at, let's call it 10:30. I need to answer a couple of things here locally, and my computer is still not 100%. I may have to reboot it, but I ought to be able to certainly get into your motions and do them straight on from 10:30. Work on other things.
Thank you, Your Honor.
That's fine, Your Honor. Thank you.
The box is the same one as yesterday. Do you want us to put it back in chat?
No, so all that's left is the Johnson, or are there additional motions?
It's just Johnson, plus if you'll recall, KMG's supplement is also involved
Still
in
going,
Johnson.
okay. Okay, no, I still have all of that. I make a different folder for every day.
Thank you.
Hearing. All right, and Ms. Portas, did you answer on a case? You said you were on another.
Yes, Your Honor. I'm here for Troy Capital on a case that looks like, I'm not sure if it's actually on today's docket, but it's Troy Capital versus Jonathan Torres, cause number
It's on page
1811.
one of the Karn's docket, Judge, the third case down.
All right, hold on a minute.
1811-0273.
Yeah, I've got problems going on here with my Karn's docket. Let me re-download that.
I cannot hear.
I'm sorry, I said I have problems with my Karn's docket. I look at stuff and then it goes away. So let me download a different copy. Okay, I've got that open. Mr. Vestal announced present. I see. I don't know what the hell's going on.
Judge, I'm still present and I'm trying to
Right.
help the adverse party log on right now.
Thank you. Investment Retrievers versus Enrique Ramos.
Your Honor, counsel, I've currently for defendant, it's my motion to withdraw.
Okay. All right, I'll look at that in just a moment. I'll mark you number one.
Thank you, Your Honor.
Troy Capital versus Jonathan Torres.
Yes, Your Honor. I'm answering for that one. I'm attorney for plaintiff.
Right. Okay, how long?
Less than 5 minutes.
It's
on a motion for default judgment that I think was already granted on the 15th of last month. We just filed an amended order and an amended attorney's fee affidavit.
Okay. Jeremy Swerk versus Zachary Yanta.
That case was dropped, Judge. Reset on request.
Okay. Joaquin Leja versus Spotted Lakes.
That case is also dropped, Judge.
And let's see. I think where they're conferring on SIM and the other two pro se defendants already. All right.
Yes, Your Honor. This is Attorney Megan Myerson on that SIM matter. Attorney Ana Laura Hesbrook said that she is in the waiting room and just hasn't been let in yet. It's just a motion to enter. I simply can't sign it because my client won't let me, but I think it matches our MSA.
All right. All right. Ms. Hesbrook.
Yes, I'm finally in here. I apologize. I was having technical difficulties.
Well, I'm having all kinds of issues this morning, and it's supposed to go beep whenever somebody gets to the waiting room, and that did not happen. So I'm sorry you had to wait there. All right. You have your proposed order.
We do, Judge. We have the proposed order. I can submit it to the court if it hasn't already been as part of our motion to enter.
Okay.
I think Ms. Meyerson's the one who prepared it, actually.
I'm just unable to sign it now at this point, but I do believe it matches the MSA.
All right. If someone will post that to me in chat, I will. Is that a final order?
Yeah. It is, Your Honor, based on an MSA.
Okay. All right. If someone will post that to me in chat, I will sign it and post it to the district clerk.
If I could have you do that, Ms. Hesbrook, so that it has your signature on it.
Okay.
Thank you.
I will do that. Thank you.
Judge, I emailed you the additions, just in case you weren't able to pull them up off the internet.
Yes.
Sal and Wilson.
No, I didn't see any when I looked, and I have a big red asterisk looking thing over my mail. Let me see if I can get anything.
Judge, do you want me to bring a copy of the docket to you?
No, just post it to me in chat, please. I have not received any email since 4 o'clock yesterday afternoon.
Yes, sir.
It did this yesterday.
I just posted those 2 additions in chat for you, Judge.
Thank you. Okay, Wilson civil additions in the interest of the Alcala children.
Yes, Judge, Tony Reyes for the movement.
Okay, and who's supposed to be on the other side?
I represent the father. The mother, a couple years ago, had Judge Renee Diaz, but he withdrew for failure to be paid. So she has no attorney at this time, and she is on the run. I've submitted 2 pleadings. I know the court is extremely busy, but there's
That's fine.
There's 2 affidavits on file. The mother was recently kicked out of a house. She was living with her mother, and she and her husband have been kicked out of the house of being accused of theft. That grandmother, as well as the mother's sister, are working with CPS, 2 people's names, which I put in the affidavits. They're looking for this mother at this time. She's basically abandoned these 2 boys that are the subject of your case, as well as 2 other children she has from a prior marriage. And we're not trying to take anybody's rights away or anything like that. Our immediate need and the need for this restraining order is to get these children enrolled in school. They have to be withdrawn from the school in Lavernia and enrolled in the school that serves the father's house, because that's where the kids are now and have been for 2 or 3 weeks. And it's Bob Hope Elementary in Southwest Independent School District. And that school won't let them officially enroll until they officially withdraw from Lavernia and enroll in Bob Hope. And then also it says in there that the mother is to, cooperate with anything and everything that CPS requires. They've asked her to take by phone, they asked her to come in and take a drug test along with her husband. She refused to do so. So it's just kind of a awkward, difficult situation. But the main purpose of this TRO is get these kids enrolled in school, at least for 14 days until we can have a hearing. And hopefully in the next 14 days, these 2 investigators with CPS can locate this mother. She's supposedly living out of, she informed them, who informed my clients, that she's admitted that she's living out of a car at this time. So that I gave you a lot of information in a very short period of time, but anything you need from me, Judge, please let me know and I'll try to answer it.
Okay, I'm reading your affidavits right now.
Yes, sir.
Judge, this case is not open.
Okay. What does that mean?
It's not reopened.
There's been no motion to modify or enforce. It's been closed, I believe, since 2020.
That long. No, there's a motion for further temporary orders and motion for temporary restraining order, but there's no motion to modify. I see what you mean. All right, Mr. Reyes?
Yes, sir.
I will agree with the clerk that I think that there has to be a motion to take some positive action, and then I could give temporary orders and things. So I will ask you to get that, just, it can be a 2-page motion.
I'll do so.
And then I'll take judicial notice of the affidavits, and I will, there's a motion for evaluation, and I'll.
And I don't need that signed at this time. We just need, I'll get that motion. I'll just put a real quick 1-page motion to modify.
Please.
Get it filed and sent to your attention.
Okay. All right. And it would be even quicker if you could remain online. You can minimize your thing, shut everything off, just post it to me in chat and make sure I know it's there and I can sign it and give it straight to the clerk.
I'll do so, Judge. Thank you for your time.
You're welcome. All right, and on the LaSalle add-ons, EP Energy versus Charlotte Prince.
Your Honor, this is Austin Brister. I represent the Multiple Story Ranch parties. We did not intend to have anything said in that case, Your Honor.
Okay. And then EP Energy versus Lawrence Robertson.
Your Honor, same thing. We did not intend to have anything said in that case either.
Maltzberger Story versus Watson.
Same thing with that one, Your Honor. Oh, actually, Your Honor, that particular case is the one I said I was going to mention that we are passing on.
Okay.
So we did have something set, but we're passing on that one. Answers were filed for each of the default judgments we were seeking in that case.
Okay, Maltzberger Story versus Sally Gents et al.
Your Honor, that is one of them that we discussed earlier with one motion for default judgment.
Okay.
And I, like I'd mentioned before, we think we could probably hear those consolidated together. The issues are all very similar.
Right.
Involves the same rant.
Okay, and Maltzberger Story versus McLean, that's the other one you announced on. All right.
That's right, Your Honor.
Okay, motion to withdraw investment retrievers versus Ramos.
Yes, Your Honor. Ben Trotter.
All right. Have you notified your client, Mr. Trotter?
Yes, I have copies of the certified mail, both when I sent him the motion and proposed order, as well as when I notified him of the hearing.
All right, and we don't have any telephone numbers, but is Ben Trotter, I'm sorry, is Enrique Ramos online under a different name?
Judge, we received an email from the district clerk's office saying he filed an answer saying he would not be present this date due to a doctor's appointment that he couldn't reschedule.
All right, then, if you
He
will,
has a phone number on there as well.
that's great, but he didn't ask for a continuance.
Yes, sir.
Okay. All right, Ms. Trotter, if you will post your proposed order to me in chat, I will sign it.
Great. Thank you very much, Your Honor.
All right. Troy Capital versus Jonathan Torres.
Good morning, Your Honor. This is Claire Portis. I believe this is set for, I'm showing that you granted a default judgment back on 12/15. And there was an issue with the amount of attorney's fees. We filed an amended motion for default judgment on the 21st of December with an attorney's fee affidavit with those changes from $2,500 to $1,500 and an amended order.
Okay, give me just a moment. Let me pull that up on Clerk's records. All right, I don't see where there's been a default judgment signed. I see where there was a proposed order was signed, a proposed judgment was filed on the 21st of December, but I don't see where anything was signed.
Okay, I don't mind proving it back up. I have notes from the file. I wasn't here for the last appearance, but I think it was on the 15th of December. You agreed to the damages, but you said the attorney's fees need to be adjusted, and but I can go ahead and I can prove everything back up if you want.
All right, let me see.
I think Judge Ellison was on that docket, Judge, on 12/15.
Okay, well, that's why it didn't sound familiar. Okay, give me just a moment. Okay, and you may have gotten a garbled report because the return of service was not filed until January 3rd of this year. So let me see.
I'm showing that they were served on November 24th of 2018.
This is 1811-273.
Yes, Your Honor. Suit was filed on November 6th, 2018. They were served on November 24th, 2018.
Okay, what I have here is citation issue, a request citation on December 4th of 18. A citation was issued, or it says reissued and mailed to EZ Messenger on December 6th of 18. And it was served on December the 29th.
Of 2018 or 2020?
2018. Okay, all right. Let me look at your motion. And I take it the military service affidavit.
Yes, Your Honor. Military service affidavit and address, last known address are both attached to the motion.
All right, and is the proposed judgment that's on file, what, Judge Ellison wanted to reduce the attorney's fees?
Yes, I'm showing that the damages that we're requesting, the $25,917.51 was awarded, as well as court cost. And he wanted the attorney's fees reduced from $2,500 to $1,500. So we have filed a new attorney's fee affidavit and a judgment that reflects that adjusted amount.
Oh, okay. I would have just given you less than you'd asked for, whatever. And I'm sorry, ma'am, I know that you're just get put into this. I've been in that position, but do you have any idea what the defendant's date of birth is? Is that in your, I didn't see it. I thought maybe it'd be on the loan contract, but I didn't see it.
Sorry, Judge, I'm usually ready to answer any question. I have not answered a.
And I'll tell you why I'm asking that. The report from the Defense Manpower Agency is more than 2 years old. And, you know, if he's 70, certainly I'm not concerned that he's enlisted in the military in the last 2 years.
Your Honor, I'm not sure I have that information. We did. I understand what you're saying.
All right. So what I'll say is I need to know. Let me just say that I need a new military service affidavit just because it's been 2 years. And if you want to instead just file something that says, hey, he's so old that even if he'd been prior service, he couldn't go back, you know, I'll consider that. But the easiest thing would be you'll just tell them to just e-file the new military service affidavit and then I'll sign the judgment.
Your Honor, actually, I think so. I think we filed the motion for default judgment that was filed on the 21st of December. I'm looking at it right now. And those have, there's a military service affidavit from the 21st of December of last year. So maybe the old motion for default judgment had a.
Okay, and I'm
had
not
the
sure
one that
if
was.
you saw that. I've already exited out of that case in Karnes County. So if you'll post the proposed order in chat, because the last order I saw was the one from 2018. It may not have made it. I will sign it.
Okay, I'm not sure I can post anything in chat because I've called in.
Oh, that's true. Okay, well, if you will get that to me somehow, I will sign it.
Okay, I believe it's on file. It was filed on the 21st of December of last year.
Okay, well, I just looked and the only thing I saw in there was, the only proposed order I saw was the one from 2018. So I'll let you act at discretion on that.
Hello, Judge. This is Attorney Megan Meyerson. I'm sorry to interject.
Yes.
I need to go for a case in Bexar County. I was just curious if I am okay to leave this Zoom. Anna Laura Hesbrook was sending in an order in our case for you to sign.
That's great.
Okay. Thank you, Judge.
All right, and is the Karns District Clerk here?
Judge, good morning.
Yes, ma'am.
I looked on the documents that we have on file for the 21st on the motion and the proposed order.
Right.
And Judge Ellison did send that back and rejected that with no note, no signing of it. So we do not have access to those documents anymore.
Okay, well, that would explain it. All right, Ms. Portis, I'm sorry to go through all this, but you're gonna have to contact Judge Ellison. Apparently, he rejected that.
Okay. Okay, so we'll have to set it for another hearing, or I'm confused about why.
I don't know why Judge Ellison rejected it, but He had some reason, and I'm going to ask you, you're going to need to get in touch with him through the coordinator's office and discuss that with him.
Okay, thank you, Your Honor.
You're welcome. All right, I just posted the Ramos withdrawal from Mr. Trotter to the district clerk. Karnes County versus HMC West. Anyone?
Your Honor, on that Ramos withdrawal, since that's been submitted, may I be excused, or do I need to stay for anything else?
You're excused.
Thank you very much, Your Honor. Have a good day. Okay, in the matter of the marriage of Gianna Morales and David Cantu.
Judge, this is Beth again. I uploaded in chat the documents that she brought in and filed in the court.
Thank you.
I'm here.
All right, and I'm looking, I'm looking at the clerk's records. There's been a waiver of personal appearance.
You should have 3 documents on that cause.
Okay. And are those different than? All right, what time did you upload those documents?
9:10 this morning. Titled 20-10-187-CVK.
Okay, thank you, because I've got about 2 or 3 dozen documents been uploaded this morning. Okay, Gianna Morales, are you ready to proceed?
Yes, sir.
Okay. And Dominic Campbell, are you here also?
Judge,
I'm
I
here.
also uploaded her document as well into chat, and it's under one file.
Okay, I don't know what that means.
She has two separate documents, but it'll be all in one file on hers, under her cause number in the chat.
All right, just a moment. All right, Ms. Morales,
Yes, sir.
I see your proposed divorce decree. However, Mr. Cantu has not signed it.
Right. He is currently incarcerated in Dominguez unit.
All right. The waiver of citation he signed is a limited waiver of citation, meaning that he is giving up his right to have the sheriff serve a copy on him, but it specifically says that he's not giving up his right to have notice of the hearing or anything. So I can't proceed unless he either signs off on the divorce decree or does something else to show that he is consenting to this divorce decree being issued, or you send him notice under the rules, which would probably need to be, if he doesn't have email, certified mail, telling him of when the trial is going to be.
I do have communication with him on a regular basis, and he was aware that we were going to have court today.
Ma'am. All right, but you understand that I have to go by what's down in writing. And he signed a piece of paper that said, I waive having the sheriff serve a copy on me, but I do not waive having notice of the trial unless I have signed off on the divorce decree showing that it's okay with me. All right, so I have to go by that. I need to talk to a couple of you about a couple of other things, and I want to make sure that I'm speaking to you and to Ms. Campbell also. So Ms. Campbell, can you hear me?
Yes.
All right. What I need to tell you is the law in Texas presumes that one, the husband is the father of every child born during the marriage or for 270 days after the marriage. So if there are two, the law in Texas presumes that every single thing a married person owns is community property. The instant you get married, the law presumes that everything you own it together. And the divorce decree has to either spell out how that property is being divided up, or it has to say it's not being divided up because it's separate property. And if the law does not do that, then the law says that the ex-husband and ex-wife, even though they're divorced, still own that property together. So anything that anybody owns that's valuable enough that there might be a lawsuit over it one day, it needs to be spelled out in the divorce decree who that's going to. It's not a matter of whose name is on it. It's not a matter of how you got it, when you got it, whether you are fighting over it or anything else. If it's valuable, it needs to be spelled out, because even if your ex doesn't come back and try and fight for it, their creditors can come back and try and fight for it. Two, there's also, it says, has in the divorce decrees a date, and after that date, that says each spouse is supposed to be responsible for their own debts. That date can be any date up to from the separation up to the date of the divorce decree. Typically, people will use the date of separation, but you need to put something down in there. So I'm going to need to ask you, ma'am, to reset the case and either get Mr. Cantu's signature on it, or get him served certified mail, return receipt requested. All right. Showing when the hearing is going to be, and you need to set that out some period of time. So, all right, I would say at least 2 weeks. All right.
Okay.
Thank you, ma'am. All right, and let me ask Ms. Campbell, will you raise your right hand and turn your phone on? Do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Your name, please?
Dominique Nicole Campbell.
Okay. And are you married to Willie Lewis Campbell?
Yes.
And when did the two of you marry?
January 20th, 2012.
Okay. And since that day, have there been any children born to you?
No.
Okay. All right. Has the marriage between you and Mr. Campbell become undermined due to a discord or conflict of personalities, meaning that the two of you just aren't getting along?
Right.
Is there any present likelihood the two of you are going to reconcile and live together again as husband and wife?
No.
Okay. And prior to the time this lawsuit was filed, had you been a resident of Karnes County for 90 days and Texas for 6 months?
When I filed this?
Yes, ma'am.
Yes.
Okay. And have there been any children adopted during your marriage, Mr. Campbell?
No.
Okay. And I see there's return of service that he was served on October the 26th. And he's also signed off on the divorce decree. But I need to talk to you about, we talked about property and debts, and I talked to you about how there's a presumption that every single thing a married person owns is community property. So is there anything in here that either of you own that's valuable enough there might be a fight over it one day? A business, land, okay. Automobiles, tractor, horse?
No.
All right. Now, have either of you worked at any place since the date of your marriage where you earned a retirement other than Social Security?
No. I haven't, and he doesn't work. He gets a disability check.
Okay. And you say you have or have not?
I haven't.
Okay. All right. Now, what date did the two of you, well, okay. And you're asking to have your name changed to Dominic Nicole Guzman?
Yes,
And is that a previous name?
that's my maiden last name.
Okay. All right, then, I'll find I have jurisdiction to hear this matter. The case had been on file for more than 60 days. The respondent has been served properly. His answer date has passed, and he's also agreed to the entry of this, as can be seen by his signature on the last page of the divorce decree. Petitioner had been a resident of Karnes County for 90 days and Texas for 6 months prior to the time this lawsuit was filed. The marriage has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were no children born or adopted. And ma'am, are you expecting a child at this time?
No.
None are expected, and I find that the proposed division of the marital property and debts is just, fair, and equitable. I will approve it. I will restore the petitioner's maiden name and pronounce the divorce in open court. Any relief that does not appear in this divorce decree is denied, so this is a final appealable order. All right, ma'am, there's one other thing you need to file. It's called a BVS, or Bureau of Vital Statistics sheet. And it's just a little fill-in-the-blank form that reports the divorce to the state in Austin. Have you filled out one of those?
No.
All right, if you will get in touch with the district clerk's office, they will be able to get you one, or tell you how you can get one, and you will not be able to get a copy of your divorce decree until after you have gotten that filed with them.
Okay.
Ms. Guzman, I wish you good luck.
Thank you.
All right, Mr. Vestal, did Ms. Martinez appear?
Yes, Judge, she's present.
Okay, would
Her
it
own
be
name.
cool for the two of you to confer?
We've conferred, Your Honor. I think it's pointless at this point.
All right, so let me try and.
My talking with her, I don't anticipate, she gives me the impression that she doesn't intend to put on a case. So I think that we can complete this matter in 45 minutes or an hour on the outside.
All right, well, I need to go through all of the,
I don't mind waiting, Your Honor, if you would like me
gonna be a
to,
while.
if you'd like for me to log back in at 11 o'clock or 1:30 or whatever.
You don't want to get behind the Peeler case from Atascosa County. It shouldn't take terribly long. I just need to download all these orders from Mr. Brester.
Yeah, okay, well, I'll just sit here, Judge. I'm not in any hurry. I'm not
I mean, you want to feel free to turn your monitor off and work on something else. I just.
done for.
I should have had you put these in a zip file, Mr. Brister, but that's all right. I didn't realize how many you had.
Oh, I'm sorry about that. I can still do that.
And I've gotten a dozen downloaded. I didn't know how many there were.
I did upload them in the order of the different cases, if that helps at all.
I hope it does.
There were also e-file, Judge, as well, that are in your queue.
All right, well, I'm having a lot of issues with this computer.
Judge, I also don't know if this helps you at this moment, but I have a slide, probably overkill for this, but I have a slide prepared that just sets forth the names of everyone, the dates they were served, the date the return of service was filed.
And that's fine. Let me finish downloading all this stuff.
Thanks.
All right, and Mrs. Kayla, have you had a chance to look at your records and see if there have been answers filed in any of these cases?
Yes, sir. I have on 2007-135, only 3 of the defendants are filed answer. They've all been served. Rose Barbara Wilson was served and answered.
Okay, and yeah, just say who has answered and let Mr.
Catherine Saker answered, and Nancy and Barbara answered.
Okay, and have any of those or any of those ones that you're trying to get a default against, Mr. Brister?
No, Your Honor. In that particular case, we are solely seeking default against Sally Hentz. And we've been in touch with the attorney for the other 3 defendants. I don't believe she's on this hearing, but we're not seeking default against her clients.
Okay, and who on the other cases, Mrs. Kayla?
On 2007-135. Oh, that's the one I just did, sorry. On 2006-106, nobody has answered.
Okay.
There are no answers.
And is there one more, I think?
And the other one was 2007-135. Rose Barbara Wilson answered. Nancy and Barbara answered. And Kathleen Sager answered.
Your Honor, we're not seeking default against any of those 3 names.
Okay, because very often the pro se defendants, if they file an answer, don't copy the attorney. So the attorney doesn't know until they try to take a default and they get told no.
No worries.
Mr. Reyes, your case was in Wilson County?
Yes, sir. Yes, sir.
All right, let me download that to Wilson County. And what was the name? Cantu Lopez?
Yes, Alcala. My client's
Alcala.
David Alcala, and the mother is Cindy Crawford Lopez.
And Lopez is the, okay.
Non-represented AWOL party. I represent
All right,
the
Mr.
father.
Vestal, I'm going to stop you from sharing your screen. All right. Have you spoken to the district clerk's office, the coordinator's office about when this is going to be set for hearing?
We were trying to do it it's got to be within 14 days on the 27th, but on whatever day is available for your court, I'll put on there.
All right, Ms. Riley?
Yes, Judge. The 27th is actually pretty full. The 28th would be better if that's available to him and if he's able to do it that day.
Yes, Judge, whatever day you have for us, we'll be there.
All right, I'll put January 28th.
That'll probably be actually with Judge Ellison.
no.
Do you have the grand jury that date, Judge?
That's great.
We have a lot of civil and but you're trying to get to a certain point where 40 cases or less.
Okay, Ms. Riley, would you go to the records for Judge Ellison's Zoom hearing on that date, his Zoom meeting, and give me the password and the link? I'm going to just post that to me in chat. I'm going to copy it and paste it into here.
Okay, for the 28th of January, correct? Yes, sir. Hold on one moment.
Thanks for your time, Judge Wilson.
Okay, and let me go ahead. Everything always takes a lot longer than you would hope. I'm opening up some breakout rooms, and I'm going to put Mr. Ita and Mr. Mendiola in those and ask you to confer while we're doing all the LaSalle County cases. All right. Go ahead, Mr. Brister, on your cases.
Thanks, Your Honor. Sure. Let me just share my screen. Like I said, it's probably a bit overkill. Can you see that?
No.
Oh, I have to actually click share afterwards, don't I? You see it now?
Yes.
Okay, got it. So, Your Honor, we are seeking a total of 12 motions for default judgment in 3 different cases. I would just propose, Your Honor, if you're okay with that, consolidating these solely just for the purpose of today. What's that?
Yes. Yes,
okay.
We'll hear them together.
Okay, Your Honor, each of these cases are trespass to try title cases. They each involve the Altita Ranch. My clients have been there for about 100 years. Once oil and gas development started up, several years ago, the oil and gas company went out to try to examine ancient title. They found some people, did genealogy research, and found some alleged heirs of people from deeds in like 1907. Okay. They have said, hey, there's a potential chance they could claim an interest. And so we have filed lawsuits against them, and a lot, tried to work it out, couldn't, tried to file lawsuits against them. And that's what we're here at right now. These individuals that we're seeking against today have not filed an answer. They have not resolved title with us to the extent there really is an issue there. I've placed the names on these, Your Honor, on the screen to hopefully kind of make it easy. But we have the date that they were served. Most of these were served back in August and October. There is one that was in December. But Your Honor, in each of these, the answer date has been passed. In each of these, we also have filed the proof of service, and the rules say that those have to be on file for 10 days, and each of these have been on file for more than 10 days at this point.
Okay.
Your Honor, in the Texas Rules of Civil Procedure and the Property Code both say that when there is a no answer default, we should be entitled to a default judgment, and they specifically state that we don't have any burden to present any evidence of our title in this. Your Honor, what we are doing in this is we're also seeking a motion to sever. And so that'll make each of these final, because, you know, there are some defendants, we're still trying to find out where they are, trying to serve them. As you'd heard in one or two of the matters before you today, there are other defendants who filed an answer. And so by severing them out and also entering a default judgment, that'd make them be final instead of just sort of pending here in sort of purgatory for who knows how long these other cases go once we get them served. In each of these motions before you, we have an affidavit of last known or a certificate of last known address. Those are in all but maybe one instance, they are the addresses we were actually able to serve these individuals at. We've also included an affidavit regarding the service member status, and we've also attached to that affidavit what we downloaded from the military website, in each instance showing their date of birth, and also showing that there were no records for them. And so that's what we're seeking there. I'm happy to answer any questions if you would like. I know there's a lot of things I've uploaded, but they're all very similar, and I think I've touched all the bases on that.
Okay, and is there... All right, I'm just looking at your judgments.
Okay.
Okay, I want to look all these over. I'm not going to be able to sign them right now because I've got a bunch of other things to get
to.
But they look correct. All right, and as far as the severance, would it be appropriate to sever these in such a way that if there are 5 being severed out of one case, that we just have one severed case? So the cut down the number of new cause numbers or extended cause numbers the clerk's office has to create?
Yeah, Judge, that would be completely fine with us. I didn't know if you'd want to do that. I actually proposed in my order, both the order of severance and in my default judgment, I did not do that. I put the A, B, C, D, and so on in all of them, but that could easily just that one thing be changed in both orders. And that would be fine with us.
And let me ask, Mrs. Skay, does it matter to you, or would you prefer it to have just one?
It's up to you, Judge. It's easier for us if it's just one.
Okay, we'll do it so there's just one. Okay, all right, give me just a moment. All right, you are excused. Okay. I will look at these.
Your Honor, I do have one other motion before you.
Oh, I'm sorry. All right.
No worries. No worries. So I can just share my screen one more time super quick here. Okay, so the other thing we have in front of you is in that that matter with Effie Record as the first name defendant. It's one that we had already discussed. It is this one here, the 20-06-00106. Your Honor, we have learned that Mrs. Effie V. Record actually is deceased. We learned that after we filed the lawsuit and attempted to serve with process. We did an exhaustive statewide electronic search to see if there's any probates filed. Couldn't find any. We searched Tarrant County as well. That's her last known address. Didn't find any probates there. We did end up finding an obituary online that named three children of hers. And so under Rule 152, we're just seeking an entry of suggestion of death. And then also we'd like to request writs of scarificacius. So in other words, a citation, essentially, so we can go out and get those presumptive heirs served and dispose of that issue in this title case as well.
Okay, and did you upload your proposed order on that?
I did upload a proposed order. It's just an order granting application for writ of scarificacius and recording suggestion of death. I have writs also drafted up that I could email to the clerk if that would be preferred, or I could file them with a letter, whatever would be preferred. But we have those drafted. I have not filed them.
The drafts are fine. You can send those.
I'm sorry, what was that?
You can send the drafts. We'll go ahead and do those.
Okay. All right, thank you.
Okay, all right, then I will sign all of that, and if that's all you have, you're excused.
Okay, thank you very much, Judge. Have a good day, everybody.
Thank you. All right, Mr. Vestal, I need to put some information in on Mr. Reyes's order, and then I'll start on your case.
Great, thank you, Your Honor.
All right, Ms. Trinidad, I've just sent you the signed temporary restraining order in all color. And
Thank you, Judge.
all right.
Thank you, Judge, for your time.
Yes, sir. Have a good day. Let me get to let me pull this 149201. Let me pull that up in the clerk's records. All right, so Mr. Vestal, I see a motion to modify parent-child relationship from June 25th. Is that the live pleading?
Correct, Your Honor. Karen, if you can hear me, you should probably unmute yourself right now.
All right, calling 149201 in the interest of MLG, a child.
We're ready. The petitioner's ready, Your Honor. Estimated time 45 minutes to an hour.
Okay. All right, and are you Karen Martinez?
Yes, sir.
And are you ready to proceed, ma'am?
Yes, sir.
Mr. Vestal, what witnesses do you expect to have?
I'm going to call my client, and that's all, Your Honor.
And your client is Joseph Garza?
I will call the adverse party as well.
All right. And other than yourself and the child's father, Ms. Martinez, are you expecting any witnesses?
No.
All right. Mr. Garza, would you unmute your phone, please? Or whatever you're on, electronic device?
Yes, sir.
That's you and Ms. Martinez to raise your right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
All right, so your name for the record, ma'am?
Karen Martinez.
And your name for the record, sir?
Joseph Garza.
All right, you can, thank you. You can put your hands down. All right, and let me look at the motion here. And Mr. Vestal, what are the issues we're looking at today?
We're seeking to modify custody subject to a CPS removal.
Okay, and prior to the CPS removal, or what is the last order in this case?
The last order is the divorce decree dated November 25th, 2014.
Okay. All right, and what did that provide?
That gave Ms. Martinez custody of the child. My client had standard visitation and was ordered to pay child support.
All right, and I'll let Ms. Friel and the other attorneys on Peeler case know that we've had an announcement of 45 minutes to an hour, so if you want to make that, let's make that 11:30 to ask y'all to be back. I'll let you work at your desks.
Thank you.
If you could round robin an email, I'd appreciate it, Ms. Friel.
11:30 will do.
All right, thank you. Go ahead, Mr. Vestal.
Okay, I'd like to call my client, Joseph Garza. You and Karen Martinez were married at one point, correct?
Yes, sir.
During the course of that marriage, you had a child.
Yes, sir.
Could you please state for the record the child's complete name?
Michael Logan Garza. Date of birth is 5/10/11.
And that's the only child y'all had?
Together, yes, sir.
Okay, and on November the 25th of 2014, the two of you divorced, correct?
Yes, sir.
And the divorce was done by agreement?
Yes, sir.
Okay, and as part of that agreement, Ms. Martinez was awarded primary custody of the child, correct?
Yes, sir.
And you were awarded standard visitation.
Modified custody, which would have been a little more time than our standard agreement.
So you got expanded visitation?
Yes, sir.
Okay, and did you exercise that visitation?
Yes, sir, to its fullest.
So you've maintained a consistent relationship with your son since the time of the divorce?
Yes, sir.
Since the time of the divorce, have the circumstances changed?
Within the last year, yes, sir.
And do you feel like they have changed to the detriment of the child?
Prior to me gaining custody, yes, sir.
Okay, and are you asking the court today to modify the divorce decree and to grant you custody of the child?
Yes, sir.
Are you also asking the court to order that any visits by Ms. Martinez be supervised by her mother?
Yes, sir.
Is that the way that y'all done your visitation here recently?
As of CPS becoming involved in June, yes, sir.
Okay, and are you convinced that these modifications would be in the best interest of the child?
Yes, sir.
Okay, let me take you back to the time of the divorce. In the time immediately following the divorce, everything was pretty hunky-dory, wasn't it?
Yes, sir. No real complaints.
And you guys were able to communicate, had a fairly healthy relationship.
Yes, sir.
And is it your hope that one day you will be able to that your child will be able to have a healthy relationship with his mother again?
Yes, sir.
Are you convinced that that's not possible right now?
As of recent, no, sir. I believe his well-being is a concern if he was to go back and live with her full time.
Okay, skipping forward, in May of 2020, were you contacted by CPS on May the 26th?
Yes, sir.
And what was the gist of that contact?
The chief investigator or the investigator on the case with the CPS organization, Karn, notified me that there were some allegations of neglect and possible drug use in Karen Martinez's home. And she requested an interview with Michael since he was in my custody at the time.
And did you present him for that interview?
Yes, after making arrangements with her, she was able to interview him.
And based upon your conversations with him after the interview, what is your understanding of what they discussed during the course of that interview?
He was pretty general. My son was pretty general with me about it. A lot of questions about his well-being, how he's being treated, his meals, things that he needs that he might not have or want. It was very general in that. And then I know that something along the lines of if she was sticking anything in her nose or if she was taking some pills or something along those lines were asked, and he was kind of uncomfortable about talking about it any further, but he gave me that much out of that conversation.
And your husband your son loves his mother, correct?
Oh, yes, very much.
You enjoy spending time with her, correct?
Yes, sir.
Okay. So after that meeting, or let's go back to prior to that meeting, did you have any indication to believe that she was in a downhill spiral?
Towards the end of 2019, her appearance kind of changed. It's still changing. She didn't seem to have the same appearance, as physical appearance, as far as fullness in her face and stuff. She looked like she was experiencing weight loss and was tired.
And you described that to me. She appeared gaunt.
Gaunt, yes, sir. Just unrested. She did go through a cancer treatment about 6 years ago now, and it was concerning that maybe that she was maybe coming out of remission or something to that effect because her health appeared poor.
But after the I'm sorry for interrupting you. Are you finished?
Yes, sir.
Okay, I'm not very good at this Zoom thing because I like to talk, but I'm going to do my best to not interrupt you.
Yes, sir.
She had a cancer treatment, but after the cancer treatment, physically she regained her capacity.
Oh, yes, sir. Yeah, she was very healthy.
And she was in good shape. So when you saw her in 2019, it was evident to you that there had been a significant change in her appearance.
Yes, sir.
And putting 2 and 2 together with the drug use allegation, was it your opinion that she was using drugs at that time?
To my opinion, yes, sir. I believe so. And as of April, I had contacted you possibly fighting for custody. I hired you June 1st, or May 1st, I'm sorry, to try to fight for custody prior to CPS becoming involved. In that time, up until actually getting into court, CPS stepped in and pulled custody from her.
And when you called me at that point, it was because there was an incident where you went to pick up your child one evening, correct?
Yes, sir. There was an incident where I went to go pick him. No, actually, I dropped him off. CPS had gotten involved with that family home prior due to allegations of neglect as far as her leaving the children at home by themselves. CPS got investigated and they said that it was accurate. The allegations were accurate with what they found. There was neglect going on as far as her leaving the children at home by themselves for extended periods of time.
Okay, we'll get to the CPS, but let's talk about the evening where you went to pick up your child and there was not an adult there.
Can you be more specific with that one?
Well, you went to pick up your child and she wasn't home. Your child was there with a younger child, correct?
No, sir. A police report was filed for that. He was dropped off on a Sunday afternoon with one of Karen Martinez's friends watching the children. Within an hour of driving back by and checking on the residence, it appeared that nobody was home. I got off my vehicle and knocked on the door. Her 12-year-old daughter at the time opened the door. It was just them, 10 o'clock at night.
It was a 12-year-old daughter.
Her oldest child, her daughter, was the babysitter at 10 o'clock at night. No adult was present at the home.
Did you later find out that she was at a bar that night?
Yes, sir.
Okay, let's talk about when CPS got involved. You received some letters from CPS, correct?
Yes, sir.
Okay, and at that time there were 3 children living in the home, only one of them being yours. Am I correct on that?
Yes, sir.
Okay, so one of the letters you received from CPS, which has a 1 in the top right-hand corner, it goes through each of the children, correct?
Yes, sir.
And the allegations for each of the children were negligent supervision, correct?
Yes, sir.
And in each case, Ms. Martinez was found that there was reason to believe that there was neglectful supervision of the children, correct?
Yes, sir.
Okay, and then based on that finding, did CPS then issue a safety plan?
Yes, sir. There was a safety plan issued by the investigator.
And in your words, explain to the court what the safety plan laid out.
The safety plan basically instructed me to keep my child away from her without supervision, that she was allowed to speak to him. And the fact that Ms. Martinez and Rocky Santos, which is her boyfriend, admitted to the use of methamphetamines, and that that it was not in the interest of the children to be living with her.
So CPS ordered that the children be placed in your home?
Yes, sir, for my child.
With the supervised visit?
Yes, that supervised visitation and communication was allowed.
In that, you took custody of the children on June 11th, is that correct?
Yes, sir.
And have you had continuous custody of the child since that time?
Yes, sir.
Okay. The safety plan ultimately expired, correct?
Yes, sir.
And
But
since
I've still been maintaining the rules. I've been following that safety plan up to this day.
and to notify you of the expiration of the safety plan and the fact that CPS was closing their file, they sent you a letter that has a number 3 in the top right-hand corner, correct?
Yes, sir.
And in the third paragraph of that letter, it says, if Karen Martinez, the mother of your child, tries to pick up your child and appears to be under the influence of a mind-altering substance, please call 911. Is that correct?
Yes, sir.
At that point, you realize that CPS is concerned about her drug use as well, correct?
Yes, sir.
Since that time, tell me about how much interaction Ms. Martinez has had with your son since he was placed in your home.
She's spoken to him on the phone about a dozen times. She's seen him in person about 2 times since all this happened. She tried to have a visit with him a 3rd time a few months ago, but we were out of town and we couldn't get him there within a reasonable amount of time. So he did not make that 3rd trip, but she's seen him 2 times in person since June 11th.
Is that the only time that you've been unable to give her access to the child when requested?
Yes, sir.
And when you do give her access to the child, that visitation takes place under the supervision of her mother, correct?
Yes, her mother and father at their residence, Cnty.
And are you comfortable with that?
Yes, sir. As long as they follow what I asked them to do, is not allow him to leave with her.
So
that he remains at the residence until I pick him up or they drop him off.
And should the judge grant you custody of the child, you're comfortable going forward under the same circumstances?
Yes, sir. I'm more than happy to allow her to come over to our residence and visit. I know she has a vehicle, and she can visit him here as much as she wants, or we could arrange something at her parents'.
You feel like
notice would be good.
you feel like it's in the best interest of the children that these visitations be supervised?
I feel so. As of this point, yes.
Have you received any indication that she has curbed her drug use?
No, sir.
Is it your opinion that prior to expanding her access to the child that she should be ordered to submit herself to a hair follicle test?
I believe that would be good.
And then you understand that hair follicle tests can go back a significant period of time. Are you asking the court that she be obligated to pass a test going back 90 days?
Yes, sir. I think that would be very good if she could do that.
And then at that point, you would feel comfortable loosening up the visitation a bit?
Yes, sir.
Because again, your kid wants to see his mom, right?
Yes, sir. He does. She does ask to speak to him on occasion, and he will turn her away. It is a bit of a emotional strain on him at his current age to go through all this stuff. So.
And remind the court how old he is?
As of right now, he's 9 years old. He was 8 when. No, actually, he just turned 9 when all this happened.
So when he was in her custody, how was school going?
He would miss pretty regular when he was in her care. They lived about 2 blocks from the school when he rode the school bus. His grades were low to medium. I mean, passing, but they weren't the greatest that they could have been. He's a very intelligent kid, and he wasn't performing up to his standard of what I think he could have done.
Did you receive a truancy notice during that period?
At the end of 2019, which would have been the start of the school year, would have been 2018, we did receive a truancy notice saying that if he was to miss several more days, then he could be held accountable for truancy.
Is there any explanation, medical or otherwise, why he would have been absent from school so frequently?
No, sir.
It was Miss Martinez's responsibility to get him to school, correct?
Yes, sir.
You mentioned that they lived two blocks from the school?
Yes, sir.
Was Miss Martinez employed during this time?
I do not believe so.
Do you find it curious that she chose to put him on the school bus rather than taking him to school?
Yes, sir.
Does that, in your opinion, does that bolster the idea that she was using drugs and alcohol to her own detriment?
In my opinion, it showed that she was putting off her responsibility to her children by not making sure they got to school every day when she was a homemaker.
Since June 11th, when you took custody of the children, tell me how school's going.
His grades have come up quite a bit. He hasn't missed but one day for a doctor's appointment. He's healthy. He's gained quite a bit of weight while he's with me. His eating habits have improved. Before he would eat like he'd never eaten before. Now he's kind of civilized when he comes to the table.
When you say he would eat like he had never eaten before, you mentioned to me an April 21st visit where he came over.
Yes, I think we had picked up a pizza or something along those lines, and he was pretty much putting it in his mouth faster than he could chew it and swallow it. And I imagine he had said that he'd eaten at school, but not since then. And I asked why, and he says that him and his sister would fight over food. He didn't clarify if there was not enough or what, but he was scarfing and Joe was choking on it. And it took about a month to break out of that habit of eating in that way.
Did he also mention to you that day that there was no toilet paper in the house?
Yes, quite regular.
Tell me about your employment.
My employment?
Yes.
Yes, sir. I'm a lease operator for EOG Resources. I've been there for, as of November 2010, so a little over 10 years.
And as part of the divorce decree, you were ordered to pay child support, correct?
Yes, sir.
And you realized that if you were given custody, that you would theoretically be entitled to child support from Ms. Martinez.
Yes, sir.
Are you asking the court to order her to pay child support?
If they deem it necessary.
Excuse me?
If they deem it necessary. I'm not going to hold my breath over it, sir.
Okay, since June 11th, when you've had custody of the child since then, have you continued to pay child support as a result of a withholding order?
Yes, I've had Michael in my custody since then, and I've been paying child support every pay period, which comes biweekly.
So it looks to me like that's 16 pay periods where she's received $357.69.
Yes, sir.
And that comes to a total of $5,723.30.
Yes, sir.
Correct. Has she made any effort to refund that money to you?
No, sir.
Are you asking the judge that you be awarded a judgment in that amount?
Yes, sir.
Tell me about your living situation. Where do you live?
I'm currently residing with my parents here in Runge.
So do you have a support system where you're in a position to continue to take care of your child?
Yes, sir. My work schedule, I work 10 days and I'm off for 4. The on-call situation varies, but it is very flexible in the fact that there is always an adult here to supervise him. Or I have 2 sisters, a grandmother, a mom and dad that can watch him at home. There's adult supervisors in all points in time.
Does your son seem happy and healthy in your home?
Yes, sir. It's improved greatly since initially getting moved over.
Okay, and as far as Ms. Martinez goes, where is she currently living?
According to a text message I received on December 24th of last year, she's currently living with her boyfriend's mother's home. I believe that's accurate. It's in Cnty, Nueces Street, is what I've been told.
And prior to that, was it your understanding that she lived in her car for a period?
It was rumored that she didn't have a current residence. She was evicted from her prior residence at 105 Shady Street in Cnty.
And is it also your understanding that she was kind of living from couch to couch during that period?
I believe so.
It's also, you have personal knowledge that she was evicted from the home that she was living in when things started going downhill, correct?
Yes, sir.
you think it's in the best interest of the child that you be awarded custody of the child?
Yes, sir, for now, definitely for the current situation, yes, sir, current time being.
Is there anything else that you would like to tell the judge at this point?
No, sir, I don't believe so. I mean, hopefully we can get this worked out in the future, in the near future. Maybe we can award her custody back, if the situation improves. Like I said, he does love his mom. He does want to be with her. But as the situation stands, it's not in his best interest. And it's not in my best interest for it to send him there.
And it's your opinion that it would be detrimental to the child if he was given.
If he was to return to the normal situation that we had prior to CPS getting involved. In the near future, or hopefully in the near future, maybe she can clean herself up and maybe, situate herself in a place where she was prior to all this going on. And we could talk about him visiting more without supervision.
Okay. Are you also asking judge to award you all the rights under the family code, such as the right to assent to medical care, things of that nature that would be necessary for you to raise the child on your own, essentially?
Yes, sir, please.
Okay. Anything else that you would like to tell the judge?
No, sir, not as of right now.
Okay. I have no further questions of this witness, Your Honor.
All right, Ms. Martinez, this is not a time for you to testify. Mr. Vestal is going to call you as a witness in a moment, and he will ask you some questions, and after that happens, you will have an opportunity to testify on your own behalf if you wish to do so. But this is an opportunity for you to ask questions of Mr. Garza. Do you have questions to Mr. Garza about this matter?
Not exactly questions. I would just rather just say that half those things aren't true that he said.
All right, and again, I'll give you a chance to testify on your own behalf in a moment. So do you have any questions then for Mr. Garza? The answer is no.
Yeah, like, do you really think that I would put him in danger? That I would neglect him anytime that he was alone?
Yes.
I don't have anything to say to him.
All right. And before Mr. Vestal starts, I need to ask him, do you expect that you would be asking me questions of this witness that might tend to show she committed an offense, criminal offense?
I don't anticipate it. However, if I cross that line, I would anticipate that you will jump in.
Okay. All right. Go ahead, sir.
Ms. Martinez, you heard the testimony of Mr. Garza, correct?
Yes.
And was his summation of the CPS events fairly accurate?
Somewhat.
Where do you think it wasn't accurate?
As far as the neglect, anytime that I left him at home, he was never alone himself. And when I talked to CPS, my daughter, my 12-year-old daughter at the time, was an acceptable babysitter.
There was also a younger child living in the home at that time, correct?
Yes, my other daughter.
And how old is she?
She's 3.
So it's your testimony that you think it's okay for a 12-year-old to be responsible for a 3-year-old?
Completely responsible, no, but to be able to look after her after she's already been fed or bathed, whatever it may be, yes, she is very responsible and she is capable of doing that. Or in the times that I would leave, she would already be asleep in bed, so she's looking after her, which she had a baby monitor and a phone, and we know our neighbors. She had contact with them if anything were to ever happen.
Well, CPS didn't agree with you, correct?
Well, they did.
Well, didn't they find that you had been neglectful in your supervision of the children?
No.
Did you receive? Did you receive a letter dated December the 3rd, 2020 from CPS?
Uh-huh.
You did?
Yes.
And do you remember that it said
I remember it says reason to believe.
reason to believe, which is lawyer speak for it probably happened?
Okay, well, we should probably walk around with the camera crew from now on just to get everything on, you know, have everything on record, because they sat and told me that it was okay, that my daughter was old enough.
So at the time, you had 3 children living with you. One of them was Maya Rodriguez, correct?
Yes.
That child was removed from your home under the supervision plan as well, correct?
Yes.
And that child is now living with her father.
Mhm.
True?
Yes.
Another child was Mila Cano. It was
Also removed and staying with her father right now. Yes.
excuse me?
Also removed and staying with her father right now. Yes.
And also CPS found that there was reason to believe that you had negligently supervised that child as well, correct?
Well, yeah, it's one case on all the children, so the accusations are for all 3 of them. Yeah.
Okay, so we got 3 kids. 2 of them have already been taken out of the house by their father.
No, it was all at the same time.
Okay, why shouldn't this child be removed from your house?
None of them should.
When was the last time you used methamphetamine?
Right, I'm going to interrupt you, Mr. Vestal. Ms. Martinez, I need to let you know that you're being asked about whether you might have, in the recent past, possessed methamphetamine. Possession, intentionally or knowingly possessing any amount of methamphetamine, which unless someone runs up and injects you with it without your knowledge, you'd have to possess it to use it. Possession of methamphetamine of any amount in Texas is at least a state jail felony punishable by confinement for 180 days to 2 years and a fine up to $10,000. And it goes up from that depending on how much methamphetamine a person might intentionally or knowingly possess. So I need to tell you a couple of things. I've never seen it happen, but I mean, this is being recorded. The district attorney's office could come in and based on testimony given today and use that as an opportunity to start investigation on you. So I need to tell you that you have the absolute right to refuse to answer any questions Mr. Vestal has, like, you know, have you used or possessed methamphetamine? Any of those questions that might tend to show that you've committed a criminal offense. But you have to either refuse to answer those questions or you have to answer them. By that, I mean, you can't, you know, answer questions about, did you use methamphetamine on June the 1st and then give an answer to it and then say, well, I want to assert my right against self-incrimination if you're asked, did you use methamphetamine or possess it on June the 2nd? So it's either one way or the other. You either assert your right against answering those questions or you waive it and you answer the questions. The other thing I need to tell you is that in any criminal case, the fact that a person has stood on their right against self-incrimination and said they're not going to answer any questions that might incriminate them, that may not be used against them for any purpose at all. This is not a criminal case. This is a civil case involving the welfare of a 10-year-old boy, 9-year-old boy. And I could, if you decide to answer, not to answer any questions and assert your right against self-incrimination, I could take that as evidence that the reason you don't want to answer those questions is that it's true that you had possessed methamphetamine, for instance. So do you understand those rights as I've explained them to you?
Yes, sir, I do.
And do you wish to assert your right against self-incrimination or do you wish to waive it?
I will insert that.
Okay, all right. And for the purposes of a record, Mr. Vestal, do you want to answer? I'll go ahead and let you ask the question and I'll say that she's formally asserted her refusal to answer it.
Ms. Martinez, when was the last time that you used methamphetamine?
And you're asserting your right against self-incrimination, ma'am?
Yes, sir.
Okay. All right, your next question, Mr. Vestal.
I have a follow-up question, Judge, that's kind of sits in the same area, and I'm not in any way intending to offend the court. However,
no, go ahead.
Ms. Martinez, did you in fact admit to CPS that you had used methamphetamine recently as of the date you spoke to them?
Just about a year ago.
No, that would have been in June of last year.
No, not in June, no.
Will you find it curious that in their report they wrote that Ms. Martinez and her paramour, Rocky Santos, admitted to recent use of methamphetamines?
Yeah, I'm curious about a lot of things.
You think they made that part up?
They got their information from someone else, just like everyone, all the other things that they are saying, all the other allegations
Well,
they
that's
said.
not the way I read it. It says Miss Martinez and her paramour.
So this all comes back to me not having to answer these questions. Is that correct?
All right, Ms. Martinez, what I will tell you is whether you had asked, if you've already asked and answered a question to CPS, a question about, he's not asking you if it's true that you had used methamphetamine. He asked you if you told CPS you'd used methamphetamine. So you cannot assert your right against self-incrimination for that question.
Okay. Yes, I did say that.
And what have you done since then to try to address your drug use?
I feel like you're just trying.
Have you gone to rehab?
No.
Have you participated in an outpatient program?
No.
Have you gone to any counseling whatsoever?
No.
Were you ordered to do so by CPS in order to regain your status with your child?
Ordered? No.
Were you told that if you did that, you would have a better chance of getting your rights back with your child?
I was told that it would be a great idea and it would help prove to the community that I was on the right path.
Why didn't you do it?
I called the three numbers that I had, and it took them some time to get back to me, and I just didn't go. And that just all comes down to a lot of other personal issues that I'm sure you really don't care to hear about. But I mean, that's my reason.
So essentially, you chose not to seek help.
Because I don't think I don't need help.
Okay, where are you currently living?
I stay sometimes with my boyfriend at his house with his mom and my brother.
When you say you stay there sometimes, that once a week, twice a week?
Whenever I feel like I want to stay over. I don't have a schedule or anything like that.
Are you working?
No.
Where do you stay when you're not staying with him?
Either my boyfriend or my brother. And before that, I was never living in my car. I was staying with my friend. She was living in Karn. I was staying with her. And before that, I stayed about a month at the State Motel. And before that is when I was staying in my house on 105 Shady Lane that I was evicted from. Never was I living in my car.
So you've been in at least half a dozen places since June of last year.
I believe that's maybe 3. Okay.
Would you consider that a stable environment to raise a child in?
They were all safe places. I could have had him there.
So you
And
think
he would have been very well taken care of.
You think it's okay to pack up Mike and go to your boyfriend's house one night and the next night go to a friend's house? And then
I think that as long as my kids have a roof over their head and they're fed and they're being taken care of, it doesn't matter where they're staying as long as it's not anywhere that's going to put them in danger.
Okay. Since June 11th, when Mr. Garza took control of the child, have you continued to receive child support?
Yes.
And you've received it religiously every month, correct?
Religiously. Yeah, that's the schedule. That's how it's been set up all this time.
And have you saved that money in trust for Mr. Garza to return it to him?
No, I used it to pay my car or to pay for my motel room or whatever else I needed to survive on that big amount.
Well, it's not contested that the child was in the custody of Mr. Garza during that period, correct?
Did do what?
And you agree that Mr. Garza had the child since June 11th, correct?
Yes, he did. Yeah.
Okay. Did you make any effort to return that child support to him?
Again, no, I did not.
Okay. Are you currently employed?
Nope, still not.
Do you have access to health insurance for the child?
Yes, they were, well, he was on Medicaid, or he could have, no, Joseph was providing health insurance for Michael.
So the child has health insurance now.
He has had health insurance.
Okay. The child underwent a pretty significant procedure, correct?
No, that was my youngest.
Oh, never mind. Do you have anything that you would like to add, Ms. Martinez?
No, I'll get my chance in a second, right, sir? Is that?
Yes.
Yeah.
Okay. No.
Do you really think it's in the best interest of Mike that he be in your custody?
Yes.
I have no further.
I wouldn't say best interest because I'm not saying that Joseph is not fit for him. He is. He's always been a great dad. But I'm not going to say that he shouldn't be with me.
But clearly at this point, with you living all over and
I'm not living all over.
well, you just described your living. I won't argue with you, but my interpretation of what you described is you're living all over.
Okay.
It's your opinion that he would be better off with you than living in the house that he's living in, where he has a stable home. He's been going to school. He's been doing better on his grades. He has good attendance.
I would not say better off, and I'm not saying that he's going to be better off with either one of us. He just, all of these things that you said, his grades have always been amazing. His weight, he's always, look at his dad. Have you met his dad in person? He's a big boy. He has an appetite.
Objection relevant, Your Honor.
Overrule the objection.
I didn't hear you.
Overruled.
Okay, I don't have any further questions, Judge.
All right, Ms. Martinez, what do you want me to know at this time?
I want you to know that a baby cry, so give me a second, please. I'm sorry. I love my kids, all of them. I have never put them in any danger, no matter what I have done in my own time or in my life. I've never put them in danger. I may not have the job or the money that Joseph has to give him all the finer things, but he will always be fed and clothed and taken care of. I don't think that I should be judged on some mistakes that I have made in the last year or so, because until then, I mean, I've been a mom for 13 years. And if you would meet my kids, they are amazing. I did that. I just don't think I deserve this. And my son also, Joseph's not abusive. He's not anything like that. He's very hard on him. He's very strict on him. And he was, when he was talking about CPS talking with my son, I also sat and talked with my son and said that he just wishes that he would be able to talk to someone alone. And it wasn't for anything other than Joseph's family gets upset with him if he doesn't go along with what they say, if he doesn't agree with what they think about me. They just shut him up a little, is what he's trying to tell, what he tells me. He says, I just wish that CPS would, and he said, And if you would just talk to him, he's a little genius. But he says, I know it's a little far-fetched, but I wish that, CPS would drive off and they would just stop and look in the window and then hear the conversation that we would have after that. Because anytime that he was, that CPS talked to him or anyone, Joseph was right there, He wasn't comfortable saying what he wanted to say. And I love my kids and I will never do anything to put them in any danger. And I just hope you see that.
What else, ma'am?
I have I'm sorry?
Anything else?
No, sir.
When there was a police report about your 12-year-old daughter at night minding your 3-year-old and your, at that time, 8-year-old son, your 3-year-old child. Where were you?
I was at a local game room right down the road. I wasn't at a bar. I wasn't out drinking and partying. I was just there down the road.
All right, Mr. Vestal, anything else?
I have no cross, Your Honor. I have some closing arguments I'd like to make.
Go ahead, sir.
Judge, this is a sad case, and as evidenced by my client's testimony, it's his desire that his son have a mother and a father. He recognizes that that's in the best interest of the child, that he have a supportive mother and a supportive father. Unfortunately, that's not what we have before us. We have somebody who has clearly gone downhill, and I don't want to pile on in this situation. However, in this venue, I think it's necessary. I mean, she's on a downhill spiral. She's admitted to using methamphetamine. A thorough investigation was done by CPS, and it was determined that 3 children needed to be removed from the home. Again, going back to the methamphetamine, that stuff is the devil. And I realize that the court handles enough criminal cases to realize that there's no such thing as a recreational methamphetamine user. And I think it's important to point out that even when faced with the fact of losing her children, all 3 of her children were going to be taken away. She was given the opportunity to clean herself up, and she chose not to do it. She sought no treatment. She did nothing to change her drug habits or her alcohol habits. She also is unable to provide a stable home. I think by her own testimony, she kind of lives on the fly, I guess is the best way to categorize it. And that's obviously not in the best interest of the child. We're asking that you award my client custody of the child. We're asking that you award my client a judgment for the child support that she kept when my client was entitled to possessory credits, which is $505,723.30 out of his pocket. We're asking that you set child support at minimum wage. We'd be happy with $200. My client will continue to insure the child just to assure the stability of the child's health insurance. And we're asking that any visitation that she may have be conducted under the supervision of her mother at her mother's house, and that the child is not to leave the mother's house unless the mother is in the vehicle with him.
Okay. All right. And Ms. Martinez, what are you asking for?
I'm asking that if you were to decide that he stay with his dad right now, it would only be temporary. And we could come back and I can show you that I have everything that I need to have my kids back, or to have my son back.
Okay. I've listened to the testimony carefully.
And I'm sorry.
Go ahead, ma'am.
CPS, they did not. They can't come with me. They said that would if I wanted to go and pick them up, I could. But if I were to be dirty, then that would be a totally different, you know. But they have no reason, or they said it was perfectly fine that if I wanted to go and pick them up, it would be okay.
I think
But the dad could, you know, Joseph could refuse to let me, but that I could do that.
Well,
Judge, one thing I forgot to bring up is that he's subject to a withholding order right now. I'm going to prepare an order, obviously, that follows what you order today, but our concern is the child support. I would ask that she be ordered to return any child support that she received in between now and the time that the final orders are signed.
I mean, had it not been for that child support that I kept, you know, Joseph, your son's mother, would have been living all over the place or in her car. That is what I used to get by, to live, to pay for my rooms or in my car.
Judge, there's no
He is
reason.
okay, and I don't need any more debate on that.
Okay, go ahead, Your Honor.
I've listened to the testimony carefully. Ms. Martinez, you said that you would do anything for your children?
Yes.
That you wouldn't even go and get a evaluation for drug treatment?
I wasn't even tested with CPS. I tried to get a hold of them for months up until the case was switched over from Karn to someone else.
Okay, so let me ask, if I was to suggest that we recess this trial today and you go and take a hair follicle test where they test and see whether you have used controlled substances anytime in the last 6 months, and it looks like you dye your hair, so I don't know if they'd be able to do that, but assuming they could take hair from somewhere else and do that, do you believe that it would show that the last 6 months you've not used any controlled substance? So that I wouldn't have any concern that you're still doing that? I don't either, so. Ma'am, I agree with Mr. Vestal. And I've said before, looking at my criminal dockets, a majority of the cases on my criminal dockets, the felony cases, are possession of methamphetamine, sale or distribution of methamphetamine, burglaries or other property crimes committed to get money to buy methamphetamine, or murders and assaults committed by people who are using methamphetamine. And it may be 60% or more, but certainly a majority of the cases on my criminal docket are that way. I agree also with Mr. Vestal that there are not recreational methamphetamine users. There may be 1 in a million, but I've never even heard of one. And you're going to have to stop doing that if you want to have normal access to your children. I understand that, you know, it may be something that for all of our egos that we don't like to sometimes admit we need help. I'll tell you something I've never admitted to, I think, any of the people on this Zoom hearing, and that is that I go to Alcoholics Anonymous to make sure that I don't drink, because I don't get falling down drunk, but I drink more than I should. And I've found that it helps to go to AA to make sure that I'm not doing that, to make sure that I'm not drinking anything at all, in fact. So I'm going to take a recess for just a few minutes. I'm going to put you and Mr. Vestal into a breakout room. Mr. Vestal will let you know if you want Mr. Garza in there too, because what I'm going to do is I'm going to grant Mr. Vestal the relief he has asked. I'll put the child support at based on minimum wage, but you have 3 other children, or you have 4 children altogether?
I have 3.
Okay, with 2 other children, so that whatever that number is, I think it might be less than 200. And to a judgment for the 5,700 and change, I'll put that at $50 a month to pay it back. I'll also add in a loving and caring order and an opportunity for there to be telephone / some kind of electronic communication, whether it's Zoom or FaceTime or telephone calls or something else at reasonable times between you and your child. And I'm going to put you and Mr. Vestal into a breakout room and let you discuss whether you want to build in a plan that says if you're going to treatment and if you pass hair follicle tests, if Mr. Garza has the right to demand that you go and take a urine test at 24 at very short notice or no notice, in case he has any particular concerns, see if you can't work something out that we can put into these orders that would allow you to demonstrate to Joseph that not necessarily that you would get the custody of your son back full time, but certainly that you would be entitled to more visitation and unsupervised visitation and hopefully get to at least standard visitation. But so I'm going to put y'all in a breakout room and ask you to discuss that, and I'll be back in a few minutes.
Karen, so it's gonna come up on your screen, join breakout room. So hit that, and then you and I will be together.
And that'll be in breakout room 4. So I will return shortly.
Thank you.
All right, Mr. Mendiola.
Yes, sir, Your Honor.
Mr. Ita has disappeared. Did you and he get something worked out, or?
Well, what happened was he separated from the Rosenberg law firm, and so
Right.
he's setting up shop. So his phone was disconnected, and then I was getting the mail returned. Now I have his new address, and I just sent him stuff. He got it today, so he's reviewing it, and we're gonna come back on February 11th. But we're gonna try to reach an agreement still. But it's just been since he left with Rosenberg, kind of threw a monkey wrench in the gears for him, so it slowed things down. But we're still gonna try to. Well, now that I sent him pictures of better clarity, there's been a problem since the get-go, Your Honor. And we just need to sort it out.
Okay, excellent. Well, I will put that down. So it's February the 11th.
Yes, sir. That's what Eloy said that he checked, or Mr. Eloy Hitta. He said he
Yes.
checked y'all's roster, and he said that there was an opening on the 11th of February. He's going to try to place it on that date.
All right, let me look and make sure. Well,
It's a good date, Judge.
a good date. Okay, that's fine. Okay. We'll do that. All right.
Thank you, Your Honor. Have a good day, sir.
You're welcome. You're excused.
Am I excused? Okay, thank you.
Absolutely.
Judge, am I free to go?
Yes, I don't think we have anything. That's a Karn's case, Mr. Vestal. Yes,
All right.
absolutely.
Thank you. Have a good day.
You too.
Judge, what happened with the Ann Hesbrook and Megan Meyerson case on the interest of SIM? I missed that.
They're supposed to be filing the order.
Okay.
I don't think that I ever received it, though.
Let me check the e-file, Judge.
Lori, I just forwarded the order on that cause in e-file.
Oh,
Okay,
okay.
I'm checking right now.
Excellent. Yes, because I don't see it on her.
I received it, Judge, and I just forwarded it to your queue.
Thank you. Okay, Mr. Vestal, I see you're back.
Yes, Judge, I am, and we've kind of got things ironed out to the best that we can.
Okay, what did you decide?
Okay, so we've agreed that there'll be joint managing conservators with him having the primary right to determine the residence. As you said, we've agreed to a judgment in the amount of $5,723.30. She's going to pay that off at $50 a month. We've agreed that child support will be set at $150. We've also agreed that the visitation will continue to be supervised by the mother until such time that Ms. Martinez can provide a hair follicle test showing no drug use for a 6-month period. When and if she successfully does that, her visitation will, by agreement, bump to unsupervised visits in 4-hour periods with no overnight visitation. So that will give her the chance to spend 4 hours alone with the child. So we're making a step in the right direction, but we're not ready to concede overnights at this point, given her instability as far as the living arrangements. And those visits will be done at our convenience, and she needs to give us 48 hours notice prior to any visitation, whether it be the supervised or whether it be the phase 2 visitation. We've agreed that if she receives any child support in the interim, that she will return it to him within 24 hours. And I've prepared an order terminating the withholding order that we're trying to drop in right now.
Okay, if you want to send that to me in chat.
Well, our computer skills are so limited on this end, Judge, I'm not going to make you wait. But once I figure out how to do it, I will send it to you in chat.
Okay, and that's fine. And all you have to do is just click on my name or everyone in chat, and you should have a little box appear. Well, see, I just tried to do this as an example, and it didn't happen. But if I click on chat and Rick Vestal, let's see what happens.
Yeah, I clicked your name and it came up, it said chat.
And then is there a little box that says file?
Yes.
Okay, if you click on that, then you can download, upload your file directly to Zoom, and then I can download it and I'll sign it. And is the clerk's office still on? Yes, they're still on.
Okay, so let me figure out how to get the file into there.
Give me just a moment.
Yeah, let me do some work on this, Judge, but I'm going to get you this withholding order and you can sign it, and then I'll have my client pick up a certified copy.
Okay, and what date do we want for an entry date? I can give you February 4th, if that sounds appropriate.
That sounds great with me, Judge, and I'll submit it to her. And if I don't receive it back from her, I'll submit it to the court prior to that date.
Okay, and Ms. Martinez, what an entry date is that's a date when, if it hasn't already been signed, the parties can show up and ask the judge to enter, which means to go ahead and sign the written order. Okay, I made some rulings today. You and Mr. Vestal and Mr. Garza have worked some other matters out. Mr. Vestal is going to prepare a written order and send a copy of that to you. And if you're not being asked if you agree with the written order, I understand that you don't. The only thing that you're being asked is, do you agree that the written order Mr. Vestal has drafted is what I've ordered? And if you agree that it's what I've ordered, if you will sign it, Mr. Garza will sign it, Mr. Vestal will file it electronically. No one needs to be in court again on February the 4th. If you disagree with Mr. Vestal and you don't think that what he's drafted is what I've ordered and what y'all have agreed to, try and work it out. If you can't work it out, then be back in court on February the 4th, and we'll have a hearing on that time to get a final written order signed. Okay, ma'am, and you're muted, but go ahead.
I'm here, Judge. Thank you for your time, and I appreciate you squeezing me in before lunch.
Lunch. All right, we don't do lunch, but but that's.
Yeah, I know you know, but you could have put me on the back burner till 5 p.m. and I appreciate it. Thank you.
All right, your excuse, thank you. And Mr. Martinez, Ms. Garza, other way around, Mr. Garza, Ms. Martinez, you all also.
All right, thank you, Judge.
You're welcome. All right. And is Wendy Wagner part of the Peeler case? Are you here on something else? Don't know. Okay. Are we ready to start on Peeler?
Yes, San Miguel's ready, Your Honor.
Peelers are ready, Your Honor.
KMG's ready, Your Honor.
And let me go and open up. All right, and this is actually the all right. We're taking up which motion?
Motion to exclude Gordon Johnson, one of the Peelers experts, Your Honor. And KMG supplemental motion on that same expert.
Okay. All right, give me just a moment. I don't actually have a 2A. Let me see.
In the e-file, you should have that, that order that you were needing affidavit on.
I think I had to send it back to, or you
And
resend it.
then I asked Norma to send it back to
Oh,
you
okay,
because I
okay.
brought the file so you could look at it.
Okay. All right, can someone post that motion to me? I've already moved to trash or wherever the link to the Dropbox or the box on the firm, and I did not download a 2A. I just had the 2B, the response. Or just post it in
I
chat.
sent the link, but I'll
I see.
I can get a PDF to you as well.
This should do it. All right, give me a chance to look at this and I'll be right back.
Okay, thanks.
Okay, and I just posted the order terminating child support on the Martinez Garza case to the district clerk.
Okay, thank you, Judge.
Okay, are we ready?
Yes, Your Honor. So today's motion, Your Honor, is a motion to exclude Gordon Johnson, who is one of the Peelers experts. Mr. Johnson has entered a number of very broad opinions covering a number of diverse areas in this litigation. And so just to sort of set the stage a little bit, a group of his opinions have to do with environmental contamination. So he's opining on things like what the natural background levels are, where exceedances of those background levels are, and the areas of contamination. As we heard yesterday, Mr. Johnson's the key witness by the peelers addressing areas that they allege are contaminated by salt from San Miguel. He is also the peelers expert witness on where things need to be remediated. And so he's their remediation expert. But in addition to those environmental issues, he's also opined on at least a couple of other fundamental issues that are outside of the realm of a traditional environmental expert. The first of those is he's opined that a very large area called Area B, which is part of the Peeler Ranch and also part of the mined area, the soil, the topsoil needs to be completely replaced because he alleges that the soil and the revegetation are inadequate. There's no allegation of environmental contamination associated with that. That's just an allegation that's related to the use of the particular soil types and the revegetation that took place in that area. So that's distinct. And as you'll see, as part of our argument, we're going to make an argument that he's both not qualified to render that opinion and his opinion is unreliable. In addition to that, Mr. Johnson is a Canadian, but nevertheless, and a Canadian, I'll add, with essentially no experience in coal mining in Texas. Nevertheless, he is opining about the implementation and compliance with a number of Texas state statutes and Texas regulations related to mining and environmental compliance, over which he has essentially no prior experience. So that's set the stage on who Mr. Johnson is. So what is his expertise? Mr. Johnson is a geotechnical engineer, and the court may recall we had some discussion about geotechnical engineers and some of the prior experts, but what geotechnical engineers do is they deal with earthen structures. So stabilization for foundations, building embankments for bridges, building embankments for ponds and other kinds of earthen containment structures, the construction of dams. That's what geotechnical engineers do. Now, Mr. Johnson admittedly has, in his resume, a number of places where he has expertise in certain environmental matters that touch on geotechnical engineering, but he certainly doesn't have the kind of broad experience that you would need to have the diverse opinions that he's rendered in his opinions in this case. And just to be a little bit more specific, he's not a geologist. And so those opinions that go to geology and hydrogeology, he's really stepping outside of his areas of expertise. As it relates to the Area B things about the revegetation and the soil quality, he's not an agronomist. He's not a soil scientist. He doesn't have anything in his background that gives him expertise to render opinions on those areas. As it relates to what cleanup levels should apply as part of his remediation opinions, as we've discussed in prior hearings, particularly the state action level hearing, what the peelers are essentially arguing is that there's some sort of ecological reason to require some level of remediation. Now, Judge Eva, you've disappeared from my screen. Are you still there? I just want to make certain.
Yes, I'm here.
Okay. And so he has no expertise in those areas in terms of the assessment of what is a ecological risk that would justify some sort of remedial response under Texas law. That's just not a place where he has any expertise. He, in speaking about Area B and the revegetation requirements, he is essentially entirely ignorant of the grass species that grow in Atascosa County. He has no prior experience in that. He conducted some site inspections, but those site inspections, as you will see as we go through, are fundamentally flawed and are really cursory in a way that just leads to the obvious conclusion that they're not reliable for the purposes of which they're put forward. One of the issues that we're going to talk about with Area B is an alternative cause of any isolated areas of poor vegetation, and that alternative cause is cattle cattle grazing and overgrazing in particular. And Mr. Johnson has absolutely no experience, no expertise, no ability to opine on the impacts of cattle grazing. That's not something he knows. And finally, you know, with respect to the salt issue, and we talked a little bit about this yesterday, that the primary thing he relies on in saying that the electrical conductivity, which he associates with salt impacts, is too high, is a Canadian standard, which is not a state action level. You can calculate a state action level for salt-related criteria in Texas, but Mr. Johnson did not do that. He relied on a Canadian number, which is not a state action level as recognized by the San Antonio Court of Appeals in the Taco Cabana case. So with that sort of introduction, what I'd like to do today is focus on 3 areas of Mr. Brown's opinions. There are other areas of his opinions that we've addressed in our brief, but recognizing that we have limited time today and focusing the court on the areas that I think are probably the most egregious, I'd like to focus on those 3. And so just to give the court some idea of where I'm going, the first area I want to discuss is Johnson's opinions on the alleged deficiencies in the vegetation and the soil quality in Area B, which I've also already mentioned. The second, I would like to focus on Johnson's opinions on the alleged salt contamination. And I'm going to focus particularly on salt because I think, as we discussed yesterday, Mr. Brown is not rendering opinions on salt contamination. And so Johnson's the key witness on that. And then the third thing that I would like to address today is Johnson's opinions on the application of Texas law, because as I stated earlier, he's just not qualified to do that. Now, we know we're not waiving all the other things that we raised in our motion. We're just going to rely on our briefing for that today, Your Honor, so that we can get this done and get you to your medical appointment this afternoon. I do also want to mention that like Mr. Brown, Mr. Johnson has a few untimely affidavits. KMG filed a motion to strike those affidavits based upon the timing of those. San Miguel joined in that motion. We continue to join in that motion. To the extent that the court elects not to strike those affidavits, we would include any opinions that are claimed in those affidavits as part of our motion to exclude here today, not only his reports, but also those untimely affidavits. So shifting gears to Area B, Tony, Judge, I assume I have permission to share my screen.
Yes, so you don't have to ask if you have the floor. Go ahead.
Okay, and so if Tony, if you could just bring up that first exhibit. This is a map of the Peeler Ranch. The red outline is the Peeler Ranch. The yellow outline there that you can see is Area B. And so that's what we're talking about here in terms of the area that Mr. Johnson suggests or alleges as part of his report that the entirety of the topsoil and vegetation needs to be removed, new topsoil brought in, and that entire area be revegetated. While we've got this particular map up, Judge, I'll just point out that the purple dots are the places that Mr. Johnson visited during his inspection. And you'll see that there are only 4 purple dots within the entirety of Area B. Area B is a very large area encompassing hundreds of acres. But, you know, Mr. Johnson only actually looked at those 4 purple dots that you see inside the yellow area. It's the R6, R7, R8, and R9. Okay, let's go to the next map, Tony, if you would, please. All right, this is a map of the Peeler's geophysical investigation, if you recall. And if you recall, Judge, the geophysical investigation gives you information about the soil electrical conductivity. And I'm not going to get into all of the arguments that we have about what this does and doesn't mean, Judge. But what I want you to take away from this particular map is if you look at Area B, which is again the yellow outline, all of that area is very low conductivity. So even according to the Peeler's view of the case and their view of this geophysical data, area B is not an area that has this sort of heat map character that they point to on with respect to other experts and other motions. So let's go to the next map, Tony, if you would please. So this is a map. We looked at it a number of times yesterday, Judge. This is a map of the alleged extent of all contamination area. Recall that's that pink shape that's down below area B. Again, I just want to point out to the court that none of area B is actually in the area, the extent of all contamination. And so the takeaway from these three maps that I want the court to recognize is that there is no allegations of environmental contamination in this area. And so to the extent that the peelers argue about environmental contamination with respect to area B, that is a red herring. It's a big red herring. And so what we're talking about here is just whether or not the San Miguel performed the mechanical work of putting down topsoil and replanting plants or grasses, native grasses in particular, adequately in this area. All right, so let's look at the basis for Mr. Johnson's opinions that area B, the revegetation is inadequate. So this is taken from Mr. Johnson's report, and Tony, maybe highlight the yellow part. This is the part where he summarizes his conclusion, or at least the basis for his conclusion that the revegetation needs to take place. His bullet points point to four things. The vegetation and health and coverage are not good, according to Mr. Johnson. The topsoil quality is poor. The revegetated species, including buffalo grass, Bermuda grass, KR bluestem, mesquite, and the prickly pear, he describes two of those as desirable, that is buffalo grass and Bermuda grass, and then he describes three other species that he describes as not desirable. So the third criteria is that he has made some determinations with respect to the type of grass is present and made a call as to what's desirable and what's not. And that's one of the things he's relying on for saying that this area is needs to be revegetated. And then finally, the fourth bullet point is topsoil quality and vegetation growth are better on the north part, which I don't know, that's just sort of a comment there, doesn't really go to his basis. And the conclusion he draws from those 4 bullet points is the site inspections confirmed that the topsoil salvage and replacement was not implemented in the revegetated portions of mine area B as agreed under the lease. Topsoil has clearly been mixed with non-organic soils, which has adversely affected reclamation of this area. So that's the basis for his opinion. As I said at the beginning, Johnson, he's not a soil scientist. He's not an agronomist. And he acknowledged under oath that he cannot identify those grasses that he's described as desirable versus undesirable. That was part of his sworn testimony, and we'll look at that. And so why don't we go to Exhibit 5, Tony, the deposition testimony, and let's go to page 42. We can zoom in on that. During his deposition, I asked him, at times prior to this case, have you identified KR bluestem or King Ranch bluestem? I have not. How many times have you identified Klein grass? Going up the other section. I have not. How many times have you identified Plains bristlegrass? I have not. All right, so let's now go down to the bottom of 47 there. I asked Mr. Johnson, is it your testimony to the jury in this case that you can distinguish KR bluestem, which he identified as being undesirable, from improved bluestems like Old World bluestem or WWB Dahl bluestem while the grasses are dormant? And again, those two improved grasses are desirable grasses on ranch lands. Mr. Johnson's reply is, no, it's not my testimony that I'm a vegetation expert in terms of identifying types. What I did do was get samples of the types that were identified by the peelers, by Jason, and I then took those out to the field to do the best of, let's jump over, my ability was able to identify them or not. And it is possible that some of the species or they're of similar ilk were there and looked similar to the ones that I characterized. So then I followed up. So it's fair to say that you would not say you were an expert in distinguishing KR blue stem and Old World blue stem. Is that right? That's correct. And it's similar, you would not be able to identify KR blue stem from WWB doll blue stem, correct? That's correct. Now let's go over just to that other column there. And this is important, Judge. This is what Mr. Johnson did as an expert. And we got to this a little bit in the answer before, that what he testified to is Jason Peeler, who is one of the parties in this case, took pieces of grass and gave them to him and identified them to him, something he had no prior experience with. And then he taped them to pieces of notebook paper and took that around, and as part of his quote unquote expert opinion, tried to compare those pieces of grass that he got from Mr. Peeler and identify the grasses. And this is the testimony where I asked him about that. So these were actually pieces of grass that Mr. Peeler gave to you. That's what I asked him, Mr. Johnson's response. They were species of grass that were identified and pointed out to us by Jason. That's Jason Peeler. We then took examples of them, Scotch taped them to a piece of paper, wrote what it was, and then so you didn't lose track, at least at each of the sites where we were able to identify grasses that were potentially lined up with those, we made out our characterization based upon those samples. That was his quote unquote expert method. By anybody's definition, that is not an expert method, particularly for a witness who has absolutely no experience in Texas grasses. If you go back and you look at Mr. Johnson's report with respect to his conclusion that San Miguel needs to spend literally millions of dollars digging up, replacing topsoil, and revegetating Area B, there is absolutely no data to support that opinion. There's no soil sampling, Your Honor, no soil sampling, not even at those 4 limited sites that he looked at. There's no soil sampling. And as the court may be aware, you can do soil sampling for key criteria of, organic matter and key cations and anions in the soil to identify healthy soil. He didn't do any of that. He's not a soil scientist. He's not an agronomist. He has no experience with South Texas soils. He did do an inspection, but that inspection was grossly inadequate. As we just showed the court, he looked at 4 sites. For those 4 sites, he spent less than 30 minutes there. He testified in his deposition that he may have looked at 1 acre, maybe 2 acres, out of the hundreds of acres that are part of Area B. As part of this inspection, before he went to the inspection, he sent an email to Ms. Whittle saying that he needed to do mapping. And so, Tony, let's pull up exhibit number 6. This is the email that Mr. Johnson sent to Ms. Whittle in October of 2019, stating, I would like to complete a more detailed surface survey of the property. This would entail mapping vegetative stress and precipitation of salts. But we asked Mr. Johnson about this email during his deposition, and in fact, he never did any mapping. So let's go to that deposition testimony. That is the deposition. Let's go to page 30. Let's focus down there at the bottom of the page, starting at sort of line 22. And so I asked Mr. Johnson, and it's correct to say that you didn't create a map of either vegetation stress or precipitation of salts, even within the immediate area of the sites that you looked at, correct? You didn't do a map, did you? No. So Mr. Johnson didn't do what he told Ms. Whittle he said he would do, he needed to do. And the testimony, and I won't go through all of it, but the testimony was essentially that the maps that he created and the conclusions that he made from those maps are essentially what he remembered about his visual inspection from several months ago of a ranch that is, over the area that he looked at was probably over 5,000 acres. That's not reliable, Your Honor. It gives us nothing to test in his deposition. And the idea that somebody could keep in their head the areas that they're going to identify within 5,000 acres that's just not the scientific method. That's not the kind of evidence that Texas courts should admit as part of expert testimony. There's also a key issue with respect to Area B as far as alternative causes. We looked at the cases yesterday, both Mitchell Energy, which was a Texas case that talked about the need to carefully consider and rule out alternative causes. We also looked at the federal Meritor case, which says if you're going to say something's the sole cause, you have to show that it's highly improbable that alternate causes are not contributing to whatever condition you're identifying. Well, in this case, with respect to the vegetated cover of Area B, the peelers have been used Area B to graze cattle since at least the mid 2010s. So for a number of years. And Mr. Johnson made no effort to address the alternative cause of whether or not there was any overgrazing by the peelers' cattle. And, overgrazing of cattle can clearly cause vegetative stress and vegetative damage. So let's, just as an example of this, let's go to Exhibit 7, Tony. This is one of Mr. Johnson's sites that he looked at within Area B. So this is Area B. This is what his backup documents look like for the inspection sites in his report, Your Honor. So this is the one for R7. And let's look at the pictures. He shows the pictures of some vegetation and gaps in vegetation. He's got a picture that's, really far out that shows the location of the site. And highlighted here, I've got his conclusions from this particular site. He states, likely a result of poor soil quality. At the surface, this is considered an area of poor, incomplete reclamation, mix of topsoil and overburden. So that was his conclusions for his observations at this site. Note that there's nothing talking about cattle, nothing talking about grazing. And if you look at the discussion of this particular site in his report, there is no discussion of cattle. So we had our expert go out there and look at this particular site. And I'd like to show you a picture of what he found when he went there. So let's go to the next picture, Exhibit 8.
Water tank, yeah.
That's what he found, Judge. That is right behind the photographer of the picture that we just looked at. There's a water trough, and anybody in South Texas knows that water sources, they get a lot of trampling and a lot of overgrazing in connection with the cattle. There is no mention anywhere in his report, Judge, of cattle impacts at that site. And you saw he blamed that on San Miguel, poor soil quality, lack of vegetative cover. That's not the only evidence of cattle overgrazing in Area B. There was also an inspection that was conducted by OSM. That's the Office of Surface Mining. It's a federal agency that oversees the state of Texas's implementation of SMCRA, the main statute on surface mining. And they conducted an inspection in October of 2009 or April of 2019, so less than 2 years ago in Area B. This is a copy of their inspection report. It's dated April of 2019. And they're looking at, this is an inspection of part of Area B, an area called Area B7, which is about 330 acres. That's a subpart of the overall Area B. And if we could just jump to the third page, Tony, down there at the bottom. Both Ms. Peeler and it says Joe Peeler, but I think that's actually Jason Peeler, were present for this inspection, Your Honor, 2 years ago. If we go to the next page, just zero in on that. The purpose of the inspection was to focus on the condition of the vegetation as the post-mine land use will be used as pasture land. The land is currently grazed and reportedly has been grazed as such since around 2014. So that sort of backs up what I just said. It's been grazed for a number of years. And so these OSM inspectors, independent third-party inspector with expertise in evaluation of revegetation from coal mining, came and looked, and what they were looking at is whether or not the vegetation was being successful. Let's jump to page 6. Their conclusions as a result of that inspection were, of the 355 acres, there was no erosion as the terrain is generally flat. Ground cover was thick with an average height of around 18 inches. Over most of the areas, there was a heavy cover of native grasses with a few isolated areas showing a heavier concentration of weeds. It should be noted that there are several areas that were grazed close to the ground. Unless forced elsewhere, cattle tend to overgraze the more desirable grasses, leaving the less desirable grasses to flourish and become a dominant species. Now, Judge, Mr. Johnson doesn't have to agree with the federal government. I mean, we would submit that this is, persuasive evidence that indeed this area has been properly revegetated, but Johnson doesn't have to agree with him. But in meeting his burden to address alternative causes, and we've got OSM saying cattle are causing isolated problems in Area B, to meet his burden that he has carefully considered and ruled out alternative causes, at a minimum, he has to address this report. Nowhere in his reports does he address it. Nowhere in his reports and his discussion of Area B does he present any scientific or reliable admissible evidence related to any assessment of cattle impacts on Area B. So, in summary, with respect to Area B, Johnson's not qualified. He's not a soil scientist. He's not an agronomist. His inspections were grossly inadequate. There's no soil sampling. There's no objective soil sampling type evidence to support his conclusions. And there's no discussion eliminating cattle grazing as the cause for the isolated areas that the OSM and others have identified with respect to vegetative success. And indeed, I haven't mentioned this yet, but he's also not an expert in impacts from cattle grazing. I mean, he's a geotechnical expert from Canada. All right, so that's the first issue. Second issue that I wanted to address is his opinions regarding salt. So let's start by looking at how Johnson made his determinations regarding salt. So let's go to his report. This is Johnson's original report, and this is the section where he describes what he did to identify areas impacted by salt. So he references two surrogate measurements that we've talked about a number of times before. That is electrical conductivity and sodium adsorption ratio. That's the EC and SAR. And he states those surrogate measurements are used as representative parameters to analyze the presence of salt contamination and remediation requirements in soil. And then he references for the EC criteria the Canadian standards that we've talked about a number of times. That's the Alberta Tier 1 guidance document that he references right there in the next sentence. And then he makes one more reference. He references a document published by Texas A&M in 2015 regarding the salt tolerance of various Texas grasses that is referenced there. So there's two references, one to the Canadian standard and one to the Texas A&M article. Now, in the presentation yesterday on the Brown motion, I heard Ms. Whittle say that he also referenced a guidance document from the Texas Railroad Commission. I wasn't aware of that. So last night I went back and I looked at Mr. Johnson's report, Mr. Johnson's supplemental report, and Mr. Johnson's rebuttal report. He's got 3 reports that he filed timely in this case. Not a single one of those references any Texas Railroad Commission guidance document on salinity issues. And so if there's any argument about such a document, that's all Monday morning quarterbacking, Judge. So I would ask the same question that I asked with Mr. Brown regarding Mr. Johnson's assessment of salt issues for the Peeler Ranch. Why didn't he look at the sampling for the background data? We've got a Texas A&M article about tolerance of grasses, and we've got a Canadian standard. Why didn't he look at the background data that they spent so much money on, that they drilled 30 borings? They took samples from 3 to 4 depth intervals, and they've got all that analytical data done, including analysis of the constituents of salt, like chlorides and sodium and all the other things that we're concerned about when we're thinking about salt. Why didn't he do that?
And is there a dispute between the parties on whether Johnson did or did not take that into account? Because I read the Peeler's response is claiming that he did look at a study of 30 background soil samples in the Peeler Ranch and parts of it that were not affected by the operations. So are those the same soil samples, Ms. Whittle, or?
They are the same soil samples, Judge. I don't think there's any dispute about that. But there's nowhere, and Ms. Whittle is free to point it out to me in her response, but there's nowhere in his report where Mr. Johnson ever addresses the cations and anions associated with salt. That is sodium and chloride and all of those things that are identified in their original pleadings. And with respect to the surrogates, that is the electrical conductivity and the sodium absorption ratio, I'll go through that. I mean, Mr. Johnson purports to address those particular parameters that are associated with salt, but I think I'll be able to convince the court that his consideration of that was cursory, and what he really decided his areas of alleged salt contamination on are these Canadian standard. So I think, we made this point yesterday, I'll just cover it quickly today, is if you go back and you look at Lauren Ross's analysis of the data from those background samples, what it shows is if you use the same technique to evaluate background that you do for, that they did for the metals, for both the surrogates and for the cations and anions, the sodium and chloride, if you do that analysis, what you find is all of the data, with modest exceptions, comes back as background for salt. Now, so let's start with the Texas A&M guidance, because that is closer to home. So that's the first thing that I want the court to look at, because Johnson did look at that and use that as a basis for saying that his criteria for the definition of salt contamination applied on the Peeler Ranch. And so this is a copy of the cover page of this study. Judge, what this study is it provides data on the salinity tolerances of various grasses. And it's a study that was published by Texas A&M AgriLife Extension in 2015. And I just want to run through the grasses that are relevant here. Mr. Peeler actually sent a letter to San Miguel in which he identifies grasses that he approved for replanting as part of revegetation. And so all of the grasses that I'm about to go through are on that list that Mr. Peeler approved. And so let's go to the first page of those grasses. We can just blow that up.
And let me be clear, Mr. Johnson, these are grasses that Mr. Johnson disapproved of or thought were indications of too much salt?
Well, Mr. Johnson really was not that specific, Judge. What he said was he went through this list of grasses, looked at the electrical conductivities, tolerances for those grasses, and came to the conclusion that this particular study supported his determination or threshold for salt contamination on the Peeler Ranch. And so recall that Alberta Tier 1 criteria for the units that are covered in this publication, that Alberta Tier 1 criteria from Canada would be 2, okay? So it would be 2. It's reported in the Alberta document, I think it's 2000, but that's just a difference in units. And so it would be 2 for this study. And so, for example, for Bermuda grass, which Mr. Peeler has approved for use on his ranch, the Texas A&M determined that the salt tolerance for Bermuda grass is 6 to 8. Now we have almost no samples anywhere, even that exceed that kind of number. Bermuda grass is a very salt tolerant grass, but nevertheless, Mr. Johnson concluded that tolerance for Bermuda grass supported his conclusion that contamination should be defined as 2 or 3 to 4 times less than the tolerance of Bermuda grass. And as we discussed, I mean, this is a very, naturally salty area. It was an inland sea, as Mr. Brown's opinion at the end of the day yesterday, I pointed out to the court. So let's look at another grass. 2 other grasses that Mr. Peeler has approved as being acceptable for use on his ranch include Plains bristlegrass. Again, comparing that to Mr. Johnson's criteria of 2, bristlegrass has a tolerance of 3 to 6. So that's not close to Mr. Johnson's criteria. Klein grass, another grass approved by Mr. Peeler for use on his ranch, has a tolerance of 4 to 6. Again, that doesn't match up to Mr. Johnson's criteria of 2. The one grass that's even close, so let's just jump to the next one. This is the least salt tolerant grass that is on this table that Mr. Peeler has approved is Cytox grama, and even it has an upper range of 4, which is twice Mr. Johnson's criteria. So I would submit to you, Judge, that this Texas A&M study does not support Mr. Johnson's conductivity criteria of 2. And it does not support the applicability of the Canadian Alberta Tier 1 standard that he used. Now, before we get too far into electrical conductivity, let's quickly review Lauren Ross's evaluation of the background samples. And so, Tony, why don't you pull up Exhibit 12? This is a table we looked at yesterday of Peeler's expert Lauren Ross's calculations of The background numbers, as we talked about, a number of the anions and cations are mentioned here. Let's jump to the second page, Tony. And then let's zero in on that bottom part where we've got the text boxes. So these are Lauren Ross's calculations for the two surrogate measurements from the background sample. So this is her assessment of background using the same methodologies that she used for the metals. And her conclusion was the sodium absorption ratio data supported a background number of 26. Note that Johnson used a background number of 8 based upon the Canadian standard. The specific conductance or electrical conductivity number calculated by Dr. Ross was 6.36 based upon the background samples. Again, Johnson used a value of 2 based upon the Canadian standards. Now, Johnson doesn't explain in his report why he rejected this background data. It's not there. Now, we did discuss it in his deposition. And during his deposition, he mentioned a couple of things. One is he mentioned, well, the salt concentrations, unlike the metals, vary with depth. That he was mostly concerned from a salt standpoint with impacts on the surface soils because that's where plants grow, and that there was a variability in the salt concentrations based upon depth. And so the key SAR and the key electrical conductivity data should be assessed from the surface soil samples. Well, Dr. Ross actually looked at these background numbers just looking at the surface soil samples. And so let's pull that up. Let's pull up Exhibit 13, Tony. So if we look at this, this is another document that's taken from Dr. Ross's backup calculations for one of her reports. You'll see there where baseline refers to the background samples, so areas that are allegedly not contaminated by San Miguel. And then the 0 to 0.5, that indicates that that's a surface sample. The sample was taken from the surface down to half a foot. And so those are the key samples that Mr. Johnson explained are most important for his assessment of salt contamination. So she has a table where she's isolated just those background samples. And then if we scroll down a little bit more, Tony, she calculated background upper bounds for just that sample set. And she didn't run the 95%. She ran a 93.5% and a 96.7%. But if the 95% is in between those two. And she came up with a background number just based upon surface samples that would have yielded a number that's above 4 and probably fairly close to 5. And you can see down there the calculation. If you just do the math and you assume that it's linear, the number for 95% would be 4.95, or about 2.5 times higher than Mr. Johnson's criteria of 2. Now, the question is, why did she do that? I mean, why did she look at just the surface soil samples? Well, you can look at her notes and see why she did. This note that's got some highlighting on it, Dr. Ross states, the sheets calculate the statistical parameters for 5 parameters and lights based on instruction from Gordon Johnson. Gordon Johnson's the expert that we're talking about here today, based upon a phone conversation on the 13th of January, 2020. So 17 days or so before they were finishing their reports, there was a phone conversation where at least Dr. Ross felt like Mr. Johnson was instructing her to run these calculations based upon the background data, looking at just the surface soils, because those were the key ones for electrical conductivity. And she did that, and she came up with a number that was 2.5 times the criteria that Mr. Johnson ended up employing as part of his salt contamination analysis. Now, if you rejected this data after it had been done based upon your instruction, you would expect his report would have some discussion about why he didn't use it, why it wasn't reliable, or why he thought that the technique was wrong. If you thought that, Judge, you'd be wrong, because there's no discussion about this anywhere in his report. Now, the other thing that Mr. Johnson says is the reason why.
And let me interrupt just a minute, Mr. Sutherland, and ask Ms. Whittle.
Sure.
Is it your response? You talk about 90% of the background samples had a soil salinity below Johnson's threshold. So is it the peeler's position that there are a few isolated salty places and the rest of them, 90% of them are the unaffected lands are below this threshold?
The soil samples, Your Honor, took soil samples from multiple depths. And so they didn't show, we don't have the topsoil samples. So there's the issue of whether we're talking about topsoil or subsoil or a mixed sample. But then also I will show you during my argument, Your Honor, the USDA map, which shows the natural salinity of that topsoil, which definitely comes under his threshold.
And let me interrupt, Mr. Sutherland. You said that that 0 to 0.5 we saw a minute ago, is that on these same samples where it was taken in the top half foot of soil?
Absolutely, Your Honor. This particular calculation that we're looking at this moment represents only that very top interval. That's what the 0 to 0.5 means.
Okay. All right, go ahead, Mr. Sutherland.
And so the other thing that, the other response that Mr. Johnson made when I pressed him on this during his deposition regarding, well, why didn't you look at the background samples? Why did you go look at a Canadian number? Was he told me that conductivity and sodium absorption ratio are not concentration parameters like the metals. And so this methodology that Dr. Ross used with respect to the metals wasn't applicable because these are surrogate parameters that aren't concentrations. Now, Judge, I don't know if that makes any sense. You know, I've looked at the technical literature. I have not seen anything in the technical literature that would suggest that that makes sense. But even assuming that Mr. Johnson is correct and that we shouldn't be using electrical conductivity and SAR in this way, he had all of the concentration data for chloride. He had all the concentration data for sodium. He had all of the concentration data for sulfates. Those are just like the metals. And he could have calculated background data for those particular concentrations. He knew he had the data, but instead he went to Canada. And frankly, Your Honor, there is no explanation that makes sense that justifies that, particularly when you think about that those are the compounds that the state of Texas looks to when they're doing a state action level for salt impact. So Tony, just to remind the court, let's go ahead and bring up what was Exhibit E during the state action level argument. This is the document that we looked at before Christmas. We were talking about the state action levels, and we were talking about under TERP, how you do an ecological criteria evaluation where you've got salt impacts. And the compounds that the state of Texas points the regulated community to are calcium and chloride. We had data for both of those. Johnson had data for both of those. Magnesium, we have data for that. Johnson had data for that. Sodium, and sulfate and sulfide. And I'm not sure we got sulfides, but we definitely have sulfates, which are the key salt parameters for sulfur-related salts for geology like this. And so there's no reason, these are just compounds just like the metals are. The state of Texas says this is how you should assess it. And Mr. Johnson completely ignored it. Now, the reason why he might have ignored it is because he doesn't know anything about the Texas Risk Reduction Program, which sets the applicable state action levels. I asked Mr. Johnson during his deposition what he knew about the Texas Risk Reduction Program. And if we go to the deposition testimony again, Tony, and we'll go to page 116. I asked him, have you submitted any kind of site assessment report or remediation report to the Texas Commission on Environmental Quality? No. Have you ever had a project where you prepared an assessment and applied the Texas Risk Reduction Program protective concentration limits? That's the PCLs. That's the key criteria. No, I have not. The Peelers hired an expert that didn't know how to do the fundamental thing that they needed to do to assess the presence of pollution under Texas state law. We have additional evidence on these salt issues that are in our report. They address things like comparing the background data within various drainage channels to the actual data and drainage channels around the mine and the power plant. In the interest of time, I'm not going to cover that, but I do invite the court and would encourage the court to go and look at that, because it's an additional line of evidence that simply shows that what we're looking at here and what Mr. Johnson has defined as salt contamination is really just naturally occurring salt. I do want to draw, before I leave this topic, I do want to draw the attention of the court to a case. It's the Hess v. McLean feed yard case. This is a case where the court was looking at a feedlot and sort of a stormwater overflow from the feedlot. And the main issue is whether or not the expert, as part of his causation analysis, properly considered the pre-existing condition of the property, or in our case, the naturally present condition of the property. And so if we could just jump to the first highlight there, Tony. This is just a portion of the case where the court is just describing what the dispute was, is whether or not the manure and other sorts of byproducts that overflowed from the feedlot were causing the problems, or whether it was prior use of the property as a ranch and cattle that were just grazing. So let's go to the next highlight. And what the court said was, in addition, the expert should carefully consider and rule out alternative causes. That's the same language from Mitchell Energy. An affidavit that wholly fails to inform the reader of the quality of the water before the events made the basis of the underlying suit, or that his opinion was based upon other primary summary judgment evidence of water quality. So he didn't look at pre-existing conditions. The court's conclusion was, further, even though the expert attempted to rule out other potential causes, the failure to ascertain and consider the water quality before the events made the basis of the underlying suit renders the effort to rule out other possible causes incomplete and therefore inconclusive. That's the same thing that's happened
Mr. Sutherland, the reason I smiled whenever you brought this up is that the question I have written down is, Area B needs to be revegetated, question mark. What did it look like prior to mining? So, okay. All right, go ahead, sir. Know that?
I'm sorry?
Do we know what it was like prior to the mining?
There is some information. It's, the pre-mining surveys primarily relate to the geological condition. The prior land use was as ranch land, and there was a fair amount of mesquite, and I always say this wrong, but is it Hisachi? I'm probably got that.
Dispatch.
Dispatch,
Your
yeah.
We do have
Um,
information in the record about what Area B looked like, and we also have information that the Railroad Commission has rejected bond release in this area, and I'll go through that in my argument.
I'm going to ask the movements to be wrapped up by 1 o'clock so that Ms. Whittle has a chance to respond.
Okay. So the last thing that I said that I was going to address, Your Honor, was the Mr. Johnson's opinions with respect to Texas law. As we stated a number of times, Mr. Johnson is from Canada. If we could just pull up the Exhibit 15, the excerpts from his report, Tony. And so this is a summary of Mr. Johnson's opinions from his report. Number 3 is, has San Miguel and Kiewit operated and reclaimed the lignite mine in a manner consistent with the Texas regulations for coal mining? I won't scroll all the way through them, but we can quickly do it. There are at least a dozen different sections of the Texas Surface Coal Mining Reclamation Act, the underlying regulations, the Railroad Commission regulations that Mr. Johnson purports to render opinions about the meaning and compliance of those regulations as part of his report. And those include opinions regarding the mine reclamation. They include opinions regarding the compliance with Texas Commission on Environmental Quality, solid waste rules, and a number of different things that are unique and specific to Texas. Now, during his deposition, I asked Mr. Johnson what experience he had with those Texas statutes and those Texas rules, and the answer was basically none. So let's just quickly go through those. If we go to his deposition testimony and go to page 98, I asked him, all right, so Mr. Johnson, do you have any experience working with the Surface Mining Control and Reclamation Act? No. Now, all of these citations are in our brief, but before this project, had you ever worked on any project where you did analysis of regulatory compliance related to the rules of the Texas Railroad Commission on coal mining? To the best of my knowledge, no. I'm not going to go through all of them. There's probably 5 others where I asked him similar questions, Judge. All of those citations are in our brief. All of the responses to those were no. There's a Texas case that talks about a lawyer that wanted to come and talk about Texas ethics rules, but he was like from Alabama or someplace. The Austin Court of Appeals said that that kind of testimony was not reliable since there was no evidence that he had any particular experience in Texas that would be helpful to the jury in understanding the Texas ethics rules. The same thing applies to Mr. Johnson here. He has no experience and he has no expertise that's going to provide any benefit to the jury with respect to the application and compliance with Texas rules that he was completely ignorant of until the day of this case started. And so wrapping that up, and I want to make sure I leave a little bit of time for Kiewit, but in summary, we think all of Mr. Johnson's opinions are unreliable and they should be rejected. But in particular, these 3 that we've talked about today, Area B, the SALT opinions, and his opinions about Texas law, they just don't meet the standards for admissibility under Rule 702, Judge, and they should be they should not be admitted. And with that, I'll sit down.
Thank you.
Your Honor, I can add my 2 cents on this joint motion. There's no way that I can lay out the supplemental motion in 10 minutes. And I heard you say you wanted us finished by 1 o'clock, so I'm a little uncertain.
Well, 2 o'clock. I expect Ms. Whittle is going to have things to say, and then hopefully there'll be a little bit of time left to hear from y'all again. So let's at least get this completed before I need to leave at 2.
Okay, you're referring to both the joint motion and the supplemental motion, or just the joint motion?
I guess just the joint motion for right now, and then we'll argue the supplemental at some time before I make a decision.
Okay. Thank you, Your Honor. KMG adopts Mr. Sutherland's arguments, and I just have a few more observations. As I recall, Mr. Johnson also includes this remediation plan in his reports that form the basis for another of the peeler's damages experts, and includes estimates about construction costs or dirt removal costs or things of that nature. I'd like to point out to the court that Mr. Johnson would not be qualified to stamp or seal as an engineer any sort of remediation plan in the state of Texas because he's not a licensed professional Texas engineer or geoscientist. And likewise, he would not be in a position to submit any sort of plan for approval by any regulatory authority for the same reason. And I think if the court will remember, last December, we had this argument about one of San Miguel and KMG's experts and whether or not he would be licensed or sufficiently licensed to submit some plan to the TCEQ. And so I think the court should take that into consideration when determining this joint motion to exclude Mr. Johnson. With that, again, we adopt both Mr. Sutherland's arguments and move to strike and move that the court not consider all of Johnson's late filed declarations for the reasons that we set forth in the objections that were filed, the joint objections that were filed December 9 or 10 of 2020 last year. And we adopt those reasons as to the most recent declaration that Mr. Johnson submitted in connection with the response to this motion. And that's all I have on the joint motion, Your Honor. Thank you.
Ms. Cavazos, do you need a break? Right. Go ahead, Ms. Whittle.
Good afternoon, Your Honor. Gordon Johnson, the peeler's remediation expert, is qualified and offers relevant opinions on the environmental damage to the peeler's property and the remediation necessary to restore it to use for grazing cattle as required under the lease. To investigate and assess these damages and to develop his remedial plan, Mr. Johnson followed a methodology commonly accepted and used by professionals working on similar problems outside the litigation context. His testimony should be admitted at trial. Your Honor, Mr. Johnson himself has offered a point-by-point response to the arguments raised in the coal company's motions. As you know, we would be entitled to bring him to this hearing, and out of expediency, we have instead submitted a declaration. We've attached his sworn declaration at Exhibit 1 to our response. There is no surprise with this declaration. Mr. Johnson cites as support both his deposition testimony and the 3 expert reports we produced with our disclosures. His main report, a supplemental report based on additional test results, and a rebuttal report addressed to the coal company's experts and their opinions. Today is the first time that Mr. Sutherland and Mr. Guthrie have orally objected to this affidavit, although they have submitted similar affidavits in response to motions to exclude their witnesses. And we ask that the court reject those objections both as untimely, but also as unsubstantiated. Mr. Johnson's relevant expertise is a product of his knowledge, skill, experience, training, and education gained through his formal education, undergraduate and master's degrees in engineering, and more than 35 years experience as a licensed professional engineer working on mining operations. While he lives in Canada, he was trained in the United States and has worked extensively in the United States and all over the world. He holds a Master of Science in Civil Engineering from the University of California at Berkeley. He specializes in geotechnical, water resources, remediation, and reclamation applications to resource industries. His experience specific to coal mining includes the investigation, design, construction, supervision, and monitoring of tailings impoundments, mine waste dumps, coal ash disposal facilities, groundwater and stormwater management systems, and the design and implementation of mine reclamation programs. His experience specific to water resource management includes investigation of contaminated sites and the design and implementation of remediation systems for contaminated groundwater and surface water resources, as well as a variety of other resource development operations. He goes into more detail regarding his experience and training at paragraphs 1 through 9, 21, and 22 of his declaration, along with his resume, which is attachment 1 to his declaration. Mr. Johnson's experience is especially relevant to this case because he has evaluated the environmental impacts associated with hundreds of mining operations, coal-fired power plants, oil and gas production facilities, petrochemical plants, and cement and lime manufacturing plants. He has worked on the design, implementation, and performance monitoring of numerous large-scale remediation and reclamation programs, and he has been retained by government regulators to provide input into the assessment and approval of hazardous waste disposal facilities. Importantly, this experience includes significant work in Texas, which he explains in his declaration. Any suggestion that he is not qualified to offer his opinions in this case is unjustified. And it is particularly surprising suggestion when counsel for San Miguel previously argued to this court that San Miguel's designated expert, Mark Hemingway, is qualified to provide wide-ranging opinions, even though he has no training in those areas, because those other areas of expertise are, quote, tools in his toolbox as a general environmental expert. Mr. Johnson, on the other hand, is a licensed professional engineer with actual training and vast experience in the areas on which he opines. Contrary to the coal company's arguments, Mr. Johnson does not hold himself out to be a legal expert, and the peelers do not tender him for any point of legal expertise. Mr. Johnson, through all of the experience I just described, is qualified to discuss and explain how the technical guidance outlined in the Texas Railroad Commission regulations should be applied to the mining and reclamation activities affecting the peeler's property. That guidance is intended precisely for use by industry professionals, just like Mr. Johnson. And the rules at issue here are substantially the same as at other mining sites where he has worked, since the Texas rules are based on the federal rules. So for the same reason the coal companies argued that their expert, Bill Meister, can opine on the application of Texas rules to the site, so can Mr. Johnson. Mr. Sutherland previously argued that it did not matter that his expert was not familiar with Texas rules on mining or solid waste disposal because he has experience with the federal rules and rules in other jurisdictions. They argued the same for their expert, Dr. Powell, who is also not familiar with Texas law, yet is opining on it. Mr. Johnson's opinions on the soil and vegetation conditions on the Peeler Ranch are reliable because they are based on the same type of investigation and analysis accepted and used by professionals working on similar problems outside the litigation context. As the court is aware, the court expressly lacks the authority to second guess the expert's conclusion. Its only task is to judge the reliability of his methodology. And Mr. Johnson followed industry standard methodology in his investigation and analysis, the same methodology, in fact, that San Miguel's expert Mark Hemingway followed. Like Mr. Johnson, Mr. Hemingway relied on visual observation of vegetation stress and sodic soils, the geophysical study conducted by Peeler consultant Advisian, soil and groundwater sampling results, and published standards for vegetation stress due to salts and boron. While we do not agree with the published standards that Mr. Hemingway used for his response action plan at the northeast corner of the power plant and believe he misapplied them, his methodology using published standards to set a threshold of harm is the same as Mr. Johnson's. The coal companies make much of the fact that one of the bases for Mr. Johnson's determination of the threshold for onset of vegetation harm is a regulatory standard used in Canada. That is a good standard. There isn't one in Texas. In Mr. Johnson's experience, the Alberta guideline EC value of 2,000 microsiemens per centimeter is a reliable indicator of the threshold of onset of stress to moderately sensitive and salt-sensitive species. As we've talked about at length, there just isn't an equivalent standard that has been developed by regulatory agencies, so one has to look elsewhere. In any event, Mr. Johnson also relied on a Texas A&M study, which is specifically incorporated in the TCEQ guidance they are so fond of. In addition, he relied on the Texas Railroad Commission Field Guide for the Assessment and Cleanup of Produced Water Releases, which was issued in 2011. It's a draft guidance document from the Railroad Commission that was never finalized, but nevertheless sets out the same assessment parameters Mr. Johnson arrived at. And that guidance is still followed by operators in Texas cleaning up produced water spills, since again, there isn't anything else to follow. Mr. Sutherland claims that guidance is not included in Mr. Johnson's references, but it is in our disclosures. And again, this is a surprising argument when San Miguel's witnesses have almost no references in their reports, and San Miguel has asked the court to excuse them. Mr. Johnson used all of those to inform his analysis of the maximum soil salinity tolerable by salt-sensitive grasses and forage species, which are native to the South Texas climate in which the peeler's property is located. Those Texas publications are consistent with the Alberta guidelines he used to assess the potential onset of harm to the species that Mr. Johnson referenced. Because they all say the same thing, it is reasonable for Mr. Johnson to have reached his conclusion regarding the threshold of salts for harm to native grasses on the Peeler Ranch. The coal companies focus on that Alberta reference and argue that it is a Canadian regulation having no bearing on the Peeler's land. But their argument ignores the fact that Mr. Johnson's opinions would stand unchanged on the Texas publications alone, because those publications are consistent with the threshold for vegetation stress he has identified. The fact that they disagree with his threshold is something they can take up on cross-examination, just as we will take up our disagreement with Mr. Hemingway's threshold based on a different published standard on cross-examination. Notably, Mr. Hemingway's published standards are not consistent with the Texas A&M study or the Railroad Commission guidance. But the point is the methodology of relying on published standards for vegetation stress for developing a remedial program is sound, so Mr. Johnson's opinions should be admitted. Again, Mr. Hemingway was working under the Texas Risk Reduction Program rule. San Miguel submitted that cleanup to TCEQ as a voluntary action under TERP. And Mr. Hemingway did not develop PCLs the way Mr. Sutherland claims is necessary. Instead, he relied on published standards for vegetation stress, which was accepted by TCEQ under that voluntary program. The same goes for their argument that the Texas A&M reference contradicts his threshold because Bermuda grass, Klein grass, and Plains bristlegrass were on the list of acceptable grasses from Mr. Peeler in one letter, and they are more salt tolerant than the native grasses. They can take this up on cross-examination, and Mr. Peeler's testimony about the grasses he has approved in the mined area will not be the same as Mr. Sutherland suggested today. In any event, the vast majority of the areas requiring remediation are located outside the mine lease and reclamation area. So it is most reasonable to establish a remediation target that supports native species, such as side oats grama, which the peelers rely on to range their cattle. And it
Let me ask, is this areas where you're saying there's been water that has come off the mining
Yes,
operations?
yes, Your Honor.
Okay, so that's how salinity might have gotten from the mining operations to the peeler's property on the areas that haven't been mined.
Correct. And from the plant site, Your Honor. The plant is a significant problem.
All right, go ahead, ma'am. Go ahead.
I'm sorry, I lost my place. It's most reasonable to establish a remediation target that supports native species such as side oats grama, which the peelers rely on to range their cattle, and it is consistent with the vast majority of the baseline topsoil samples. If the companies want to argue for a higher remediation threshold based on non-native grasses, again, they can take that up on cross-examination. Their disagreement that the property should be returned to native conditions isn't a basis for excluding Mr. Johnson. In fact, Mr. Johnson went well beyond what Mr. Hemingway did to confirm that his opinion was based on local native soil conditions. To determine appropriate maximum threshold for soil salinity, Mr. Johnson studied 30 background topsoil samples collected at locations on the Peeler Ranch unaffected by San Miguel's operations. This work indicated that over 90% of the background topsoil samples had soil salinity below the maximum threshold identified by Mr. Johnson, and over 80% had soil salinity of less than half that maximum threshold. Again, we're talking about topsoil only. The Peeler Ranch gets saltier with depth, and Mr. Johnson was focused on the goal of restoring the topsoil to usable native grasses for a cattle ranch. The coal companies tend to mix apples and oranges or topsoil and subsoil to argue that the background soil samples have higher salinity than the topsoil threshold Mr. Johnson developed. But Mr. Johnson was focused on topsoil for his remediation program because, as he explains in his declaration at paragraph 27, it is impractical to remove and replace the soil to the entire depth of the observed impact. In other words, the counter defendants are trying to use Mr. Johnson's attempt to be economical in the cleanup plan against him. Of course, if they want to clean up to the actual depth of impact, then we would be open to that approach, but it would be much more expensive. Mr. Johnson's analysis was also validated by comparison to hundreds of topsoil samples collected in support of San Miguel's mining and reclamation efforts, as well as the topsoil salinity maps generated by the United States Department of Agriculture. Again, he used those maps for the purpose of looking at topsoil only, which is a more reliable way to use them given how they were generated. They become less reliable at depth. Mr. Johnson describes this process in detail at paragraphs 10 through 13 of his declaration and includes as attachment 2 to his declaration an illustration generated from the USDA website, which shows the electroconductivity of the native topsoil in this area of Atascosa County is 2,000 microsiemens or less. And I'll share my screen and show the court. Sorry. This is the map, Your Honor, of the topsoil from the USDA maps. And this shows the purple is what is above his threshold. And I can change the view so it's only, sorry, single page view. And you can see, Your Honor, the only areas that are above his threshold are here, this small purple area, here, this small purple area, and that's all I can identify. So that's the native soil, topsoil conditions on the Peeler Ranch. This is what San Miguel and the coal companies have been arguing over and over, that the topsoil is actually well above his threshold. But as you can see, Only these two areas are actually above his threshold, according to that USDA map. Mr. Johnson also explained in great detail in his report and at his deposition why he did not use Dr. Ross's statistical method for evaluating contamination to electroconductivity and sodium adsorption ratio, or SAR. He sets that out again at paragraph 14 of his declaration. There are 4 reasons he did not apply her method to establish reference criteria for those parameters. Number 1, EC and SAR are not elements with measured concentrations. They are indirect measures or calculated values, which Dr. Ross explained at her deposition. Number 2, reliance on probabilistic methods is unnecessary for EC and SAR because topsoil testing completed on behalf of San Miguel makes significantly more data available on background soil quality. Number 3, the topsoil map generated by the USDA indicates that the EC of the topsoil is consistently less than 2,000 microsiemens per centimeter in the study area. And number 4, the baseline sampling intervals reveals a significant difference between the different parameters distribution in the environment. The levels of EC and SAR were stratified and increased significantly with depth, whereas the concentrations of the remaining parameters did not. So Mr. Johnson determined that it would be inappropriate to use Dr. Ross's method for those parameters. Again, contrary to the coal company's arguments, Mr. Johnson considered and excluded other causes of the saline soil and poor vegetation. Oil and gas production, a flowing groundwater well, caliche pits, the naturally occurring native climate, and cattle grazing. He explains these in his reports and again in his declaration at paragraphs 15 through 23. Mr. Johnson excluded oil and gas production as a cause of the environmental damage, primarily because there are no records of releases of produced water from oil and gas facilities located anywhere near the large areas requiring remediation. The mine and the power plant are located between the major areas needing remediation and the only oil and gas facility with a recorded spill. He excluded native soil conditions as a possible cause of impacts to soil quality and vegetation health by closely studying the specific local background conditions and validating those against work performed by San Miguel and the USDA. And he excluded cattle grazing as a cause of the environmental damage because he observed that the areas with poor topsoil quality had no cattle grazing on them. And that observation was validated by several Railroad Commission documents he cited in his reports. And I'd like to turn to Mr. Johnson's specific opinions on Area B. Pursuant to the lease contract, San Miguel was required to selectively handle subsoil and topsoil. They were supposed to segregate topsoil and set it aside, and then place the topsoil with the saved seed bank on top of the subsoil. What the evidence will show is that San Miguel failed to do that. They either ran out of topsoil or mixed the topsoil with the subsoil such that the original seed bank was lost and the soil has not been able to support native grasses. Instead, the invasive grass KR bluestem has taken over Area B, and there are multiple very large depressions in Area B with water in them. As a result, the Railroad Commission declined to approve San Miguel's application of bond release because they didn't meet the standard for restoration to a post-mine land use of pasture land. In response, San Miguel applied to change the post-mine land use of the Peeler Ranch in San Miguel's permit to industrial commercial instead of pasture land. The post-mine land use of industrial commercial does not have the same standards for grass cover and productivity as a post-mine land use of pasture land. And under
Judge, none of this is in Johnson's report, and none of it is relevant to our objections to Johnson's testimony.
All right, Ms. Whittle.
Your Honor, this goes to the factual dispute about whether there were cattle in the area or whether this is really because San Miguel hasn't properly restored the topsoil. And I'm explaining why the inspection that Mr. Sutherland was talking about doesn't mean what he claims.
I would submit that we're not here to decide the fundamental factual dispute. The issue is Mr. Johnson qualified and is his testimony reliable? And I don't think this is
Okay.
relevant to that.
All right, well, the movement criticized the length and depth of the inspection. I'll allow Ms. Whittle to answer that.
Thank you, Your Honor. And my overall point is that there is a factual dispute, and the fact that Mr. Johnson relies on the peeler's view of what happened in this site does not mean that his opinion should be excluded. San Miguel, so the peelers did not change the post-mine land use, did not approve such a change. And so what San Miguel did was it asked Mr. Peeler to sign an approval to change the post-mine land use change for oil and gas production platforms.
Judge, this is unsworn testimony by counsel. I'm sorry.
All right, and I understand where you're going, Ms. Whittle. I'll ask you to move on to your next point.
Your Honor, Mr. Johnson is qualified. His inspections were adequate. Specifically, his inspections in Area B were adequate. And further, he relied on Railroad Commission inspections throughout the years, which all support his conclusion that topsoil is insufficient. That's why the Railroad Commission has not released the area from bond, because it has not been reclaimed to pasture land standards. And Mr. Johnson sets out the timeline for what happened in Area B and the Railroad Commission inspections that he relied on in his declaration. I think it's at paragraph 20, Your Honor.
Yes. Go ahead.
Now, just to respond to this specific point about the inspection that Mr. Sutherland referenced, and I'll move on. That was actually performed to the industrial commercial standard, because that was what the permit had as the post-mine land use. The OSMRE inspector did suggest that cattle were causing some of the problems with the reclamation of the area, and Mr. Peeler disagreed because there were no cattle in that area. In any event, the Railroad Commission has rejected the bond release application and has required San Miguel to withdraw it because the area needs to have appropriate topsoil brought in to sustain grasses and productivity. At best, Mr. Sutherland has described a factual dispute, not a problem with expert methodology, and not a basis for excluding Mr. Johnson or his opinion that Area B has not been restored to the standards set out in the contract. Finally, Mr. Johnson appropriately used the geophysical surveys as he explains in paragraph 24 to 27. He did not use the results of that survey to define soil salinity at specific points or depths, but instead he used it to identify the likely sources of salt contamination in the contaminant migration pathways and to interpolate between soil sampling locations. The utility and reliability of the EM31 geophysical survey is further verified by San Miguel expert Mark Hemingway's reliance on it. San Miguel's response action plan and associated monitoring implemented by Mr. Hemingway's consulting firm collected sampling data entirely within a zone interpreted to be contaminated by the EM31 geophysical survey, as defined by the terrain conductivity measurements greater than 250 millisiemens per meter. As it turns out, based on subsequent soil sampling, the evidence shows that salt contamination levels are much worse than those indicated by the initial delineation program, which is common when remediation programs are implemented, meaning the geophysical survey was not only correct, but actually underestimates the harms caused by San Miguel's operations. Mr. Johnson also provides quantity and unit cost estimates from reliable sources, including his own analysis, which used reliable data and methods, reclamation cost estimates, and assessments completed on behalf of San Miguel, cost information provided by other experts, and his own experience working on similar projects in similar locations. Mr. Sutherland didn't raise these arguments today, but I just want to point out that Mr. Johnson states in his declaration at paragraphs 29 and 30, relying on these types of sources is standard practice when preparing engineering estimates. Because his opinions on quantity and unity cost estimates are reliable and based on reliable methodology, they should be admitted to aid the jury. While Mr. Johnson did consider opinions provided by other experts, such as Anthony Brown, he completed his own evaluations of soil, groundwater, and surface water quality data. The only part of Mr. Brown's analysis on which he relied are the groundwater gradient interpretations. Those confirm the presence of upward groundwater gradients and the potential for salty groundwater to recontaminate any areas of surface soil remediation. Because of this potential, Mr. Johnson's remediation plan includes groundwater controls to prevent this harm from recurring. And of course, San Miguel's expert, Mark Hemingway, agrees that this is the appropriate remedial technology and has been implementing groundwater controls with an initial phase of 6 pumping wells to address groundwater impacts originating from the surface impoundments at the plant. You heard counsel for San Miguel describe this initial phase of groundwater controls to you at a recent hearing. So this shouldn't be controversial that groundwater controls are needed. In any event, all of the other evaluations of surface and groundwater are Mr. Johnson's own, and he is fully qualified to complete those technical assessments. The remainder of my arguments are regarding Kiewit, but I do Kiewit's supplemental motion, Your Honor, so I'll wait on those. But I did want to point the court to Mr. Johnson's declaration where he responds to the specific statement that he is not qualified to discuss soils. So hold one second, Your Honor. At paragraph 22 of his declaration, Mr. Johnson addresses that particular argument and says, the motion admits that I am a qualified geotechnical engineer. Discerning mineral soil from organic topsoil layers is a fundamental aspect of geotechnical investigation, and geotechnical engineering is by definition the application of soil science. My observations regarding the soil quality and the levels of visible salt impacts that are documented in Appendix C of my expert report are within my areas of expertise and practice, as is identifying salt stress to vegetation. So that's all for the peelers, Your Honor. We ask that the court deny the motion to exclude Gordon Johnson and admit all of his opinions in their entirety, and we will reserve our responses to the KMG supplemental motion for the right time. Thank you.
All right, Mr. Sutherland.
Just a few things, Your Honor. With respect to Area B, if Mr. Johnson is an expert on soils, he would know that you can sample and analyze soils and develop objective evidence of what the organic content and the like is. Those determinations are not typically made in a reliable way, just upon a visual observation. And there was no discussion that I heard from Mrs. Whittle to excuse or otherwise justify his opinions where objective evidence was typically gathered by experts that are agronomists and soil scientists. Another thing that was not addressed with respect to Area B is the fact that he only looked at 4 very small sites, maybe 1 acre, and they're asking us to completely remediate hundreds of acres based upon that minor inspection. The other thing that I heard Ms. Whittle say was part of the reason why he made these decisions is that KRB isn't invasive and is invading Area B in a detrimental way. You saw the deposition testimony, Your Honor, that Mr. Johnson acknowledged to me that he lacked the expertise to identify KRB bluestem. You can't be a qualified expert if you testify in response to a question at your deposition that you're not. And then finally, there was no discussion about the fact that explained how Mr. Johnson addressed cattle grazing as an alternate cause of Area B. I heard stuff about environmental contamination and that kind of thing, but Area B is not an environmental contamination issue. And you have a third party, the federal government, saying that that's the primary problem with Area B. With respect to the opinions on salt, Mr. Johnson's testimony in his affidavit about the consideration of samples from the background area. This is something that's addressed in our written motion. I didn't really talk about it in the oral presentation, Your Honor, but if you look at the data that was collected as part of the background analysis by Dr. Ross, there's only 5 samples that were collected in drainage channels. And drainage channels are a unique geologic feature with unique salinity characteristics that are native to this area. And so there's only 5 samples in drainage channels, but compare that to, and we looked at this some yesterday, if you recall, compare that to the areas that both Mr. Brown and Mr. Johnson are saying require remediation. 100% of the areas that they say require remediation are within drainage channels. So there's only 5 samples that from the background area that are geologically similar to the samples that they're saying need to be remediated. And if you look at those particular samples, Judge, by far the majority, almost all of them exceed Mr. Johnson's SAR standards, and at least 2 of the 5 exceed his conductivity standards. And so it's not a proper approach to the problem to compare non-geologically similar samples. And that issue is addressed in our brief, Your Honor, and I would encourage you to go read it. But the difference here is that Lauren Ross's approach is a probabilistic approach. And so it looks at the distribution of the data. And while we disagree with exactly how she went about her calculations, the methodology is a probabilistic one that takes into the account and looks at the overall distribution of the data in a way that can pick up these differences. And that's why you use that probabilistic approach. That's what they did for the metals. And as I went through in my primary presentation, all of the data for EC and SAR were present to look at that just on the surface. If they say that only the surface is relevant, you can look at all that data just on the surface. And as I went through in my presentation, when you do that, and Dr. Ross actually did that at the request of Mr. Johnson, it shows that the concentrations, native concentrations of the upper range of those native concentrations is well above the criteria that Mr. Johnson said set based upon the Canadian number. And the final point that I'll make, Your Honor, is that also on the salt issues, she gave you 4 reasons why my arguments should not be persuasive. A couple of those had to do with the depth of the samples. And as I just went through, Dr. Ross went through that and looked at the depths. The only one that really sort of touches on what Mr. Johnson actually did was the argument that somehow EC and sodium absorption ratio are not compound concentrations that are subject to this sort of probabilistic approach. As I said, nobody's told me why that is, what science supports separating them. But even if that's true, they had all the compounds. They had chloride, they had sodium, they had magnesium, they had potassium. Why didn't they use those? Why didn't Johnson use those? Because they would have been equivalent. He could have looked at those just on the surface if that's what he wanted. And if he doesn't go and look at the actual data for this particular site, it's just speculation. I mean, it's just, taking a Canadian number and speculating as to what the native conditions might have been and whether or not they might or might not be similar to Alberta, Canada. And that's not reliable, Your Honor. That's all I have to say.
Can you bring up the photograph of the stock tank, the concrete or metal? I think it was concrete above ground tank.
I think, let's see. think it's 7. No, it's 8. It's 8. Should be 8. There it is.
Maybe zoom in just on the photograph.
Can you see that now, Your Honor? Do you
Yes.
want a particular part of the photograph?
Well, I just wanted to try and get more. It's a bit blurry. If you could zoom in just to
Here,
the photograph.
let's see if we can make it a little bit better. Hold on.
Okay.
And we can get you the original JPEG if that's helpful, Your Honor. That, you know, you can look at.
Well, you can't really tell from this. I can't tell if that's clumps of grass I'm seeing or if that's cattle manure. The reason I ask that is Mr. Johnson says he had been told that there weren't cattle being grazed on the property or a lot of the property he was looking at. So that's why he didn't put a whole lot of emphasis on what impact cattle might have had. And I was just trying to see if there's indications that there's been cattle around there recently.
I think I can help you with that, Your Honor. If you look
Okay,
at
one at a time. Let Mr. Sutherland go first. Ms. Whittle, he's got the floor.
If you look at the April 2019 OSM report, which is also something that we attached, you can see pictures of cattle that are on Area B. In that particular case, it's B7. Subsequent to that inspection, the peelers stopped grazing on Area B, is my understanding. So at the time of Mr. Johnson's inspection, it in fact may be true that there were not cattle on Area B.
All right, Ms. Whittle.
Your Honor, I wanted to address just a couple of points. One is Mr. Sutherland suggested that Mr. Johnson's inspection was the only thing he relied on for his opinions for Area B, and that's incorrect. He reviewed a significant amount of documents in the record, including soil sampling that San Miguel conducted and submitted to the Railroad Commission for their bond release applications, and all of the record documents, the permit files back and forth between the Railroad Commission and San Miguel about the history of the problems in this area. I also believe that the evidence will show that Nellie Frisbee, the fuels manager, testified that she requested that Mr. Peeler remove cattle in Area B in years past, and he did, and then he was told he could go back in that area. What he told the OSM inspectors was, I'll remove them again, but I can't even keep many in there because of the problems with the property. So there may be.
And Nellie B is who?
Nellie Frisbee is the San Miguel's fuels manager. She would be the person in charge of managing the reclaimed area of the mine. So again, I believe there will be a factual dispute about whether there were cattle in the area and whether they're responsible for any part of the problem. But the record will also show that San Miguel did not properly place topsoil in the area. And that's what the contract requires. So this isn't a basis for excluding Mr. Johnson. I also want to point the court to Mr. Johnson's response in his declaration to the issue of the intermittent drainage channels that Mr. Sutherland raised just now. That's at paragraph 17. And then again, his response on the cattle impacts is at paragraph 20. And that's all, Your Honor.
Okay, are we set next week too?
Your Honor, Mark Guthrie for Kiewit Mining
Oh, I'm
Group.
sorry, go ahead.
I just wanted to give you a really brief response to the argument before last of Ms. Whittle. She represented the declaration that was submitted in connection with the response was not a surprise and contained no new opinions. I'd like to share my screen very quickly.
Go ahead.
Can you see paragraph 34?
Nope, it's not.
Nope. Okay, let me try again. How about now?
34 of what? Of Mr.
This is actually Mr. Johnson's supplemental declaration, the most recent one. You find it on page PDF page 38.
Yes, I have it.
Okay. This opinion, or paragraph 34, says on pages 15 to 17, the supplemental motion paraphrases or reiterates a number of statements I made in my expert reports. And I believe the criticism of those was that he was opining that things were possible or maybes or things like that. He adds this new opinion, in my opinion, to a reasonable degree of scientific certainty. These are the most likely explanations for the impacts to soil, surface water, groundwater, etc. That's a pretty significant add. And that is a new opinion. I guess it's a number of new opinions, depending on what's on page 15 to 17. So that's all I have, Your Honor. Thank you.
All right. Anything else today?
Not for me, Your Honor.
Okay, when are we set next?
We're set for next Tuesday, Your Honor. The one other thing I wanted to mention, on December 10th, you had asked us to submit to you a proposed damages instruction. I don't know if you recall making that ask of us. And I just know that San Miguel did submit that earlier this week.
I was confused about that, Your Honor. I thought you said that you were going to issue an order on Mr. Bolton and I can't remember the name of the appraisal expert for San Miguel, but that Schulte, that would request a certain submission from us. So we were waiting for that order.
All right, I know I've got to get some things on. Okay, well, I will hopefully have an answer for you on Tuesday.
Okay, and Your Honor, one other thing we wanted to follow up on. We intend to file a supplemental submission on Mark Hemingway due to an argument Mr. Sutherland made at the last minute, claiming that Texas had taken over the coal ash regulation in the state of Texas. That is not correct. Texas has applied to take over the program, and EPA proposed in December to approve Texas taking over. But that's currently under a comment period. There's a hearing set in February, and it is possible, if not likely, that the new EPA administrator will not accept it. So the rules that I was referring to requiring a licensed professional engineer in the state of Texas are the current governing rules. And we can file a supplement to that effect, Your Honor.
All right. Is there any?
Well, we would object at this point in time at having, counsel file sort of, tack on additional arguments about experts. We can do that too, but I don't think that's where the court really wants to go.
Well, I'm responding to what I felt was a misstatement of what the law is at the end of the case, at the end of the argument. But if the court does not want me to file it, I won't. I just wanted to clear the record on whether Texas is actually regulating coal ash in the state, and it's not.
Okay, and that was on?
That was on Mark Hemingway, Your Honor, and our argument that he's not qualified to talk about the federal coal ash rule since he's not a licensed professional engineer in the state of Texas.
but he is a licensed professional geologist in the state of Texas, which is what's required under this Texas remediation statutes, Your Honor.
But Texas hasn't actually taken over that program. So that rule that you showed is not in force.
All right, I will take those arguments in consideration. Look at it.
Thank you.
All right, we'll see you all on Tuesday.
Thank you.